Yes, madam.
Your Lordship, in this matter, the matter is ever since the matter is very urgent and which your Lordship-
Fresh matter.
No, it is a pending matter. There is already a stay. No, 1 minute, my lord. They have initiated proceedings for possession again
Possession by whom?
by the Surface Act.
Surface Act is not before us.
No, my lord. this
DRT
GM.
is not before.
No, there is already a matter. They had initiated.
Madam, those all wrong classification which have happened of surface matter.
This is a pending.
I post before appropriate bench on that. Yes.
This is before him only now. GM wrestle, pending matter. GM wrestle.
If it is in orders category, it won't reach. Please comply with your office objection, then it will reach.
GM wrestle.
Madam, if you don't comply with the office objection, we can't help. It will come in orders.
Need kuda note.
Kodi, Bharat.
My
Yes.
lord, this is.
Ah.
Sir, Monday.
You go to Cyber Command on next Thursday, that is 27th. ನೆನ್ನೇನೋ 13 ಸೆಟ್ಲ್ ಆಗಿದೆ, ಅದೂ ಸೆಟ್ಲ್ ಆಗ್ಬೋದು. ನಮ್ಮ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಬಟ್ ಯು ಕ್ಯಾನ್ ಗೋ ಟು ಸೈಬರ್ ಕಮಾಂಡ್ ಆನ್ ಥರ್ಸ್ಡೇ ಅಂಡ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ದಿ 31st. Yes. Seniority. Fresh matter kodiyappa baratte. All fresh matters are coming up before this court in 3 days' time. You don't even need to move.
Sir, court of sir. Court of sir.
If you are complied with all the office objection, it will come before the court. If not, it will go before the registry on the 3rd day. Kodi.
My lord.
Yes. Pending matter. Then file contempt, madam. It will come in seniority only. Fresh matter. Give it. 3 days is Tuesday, Allah Bharat. $230. Parole matter move madbeka. Kodi.
My lord, once extreme urgency, my lord. Women advocates of Chikmagalur Bar Association, my lord, they've been denied with the post of treasurer, which is a direction.
No
of-
reservation.
Please, my lord. Monday is the last date for filing of 2 o'clock is it?
2:30.
Please.
Serve it on,
No.
who
my
is the
lord.
association?
Association, my lord, 4 o'clock they left in the morning, my lord, women's, my lord.
No, how do we pass an order without service
Lord,
on that?
I'll try serving the association.
They're fine.
I'll-
You are entitled to, otherwise it will be violation of Supreme Court
I'll
order
try
and theory.
serving
My
the,
lord,
my lord,
in
seniors
such
committees.
case, my lord, the petitioners are the advocates.
Huh.
Let my learned friend call those petitioners in
They
Chikmagalur to
won't
serve the
come.
copy of the president.
No, I'll ask them to log
Serve the
in.
copy of the president.
This is the
No,
fourth
not a
matter,
president, no. It's a seniors committee, my lord.
fourth matter coming up, I think, where the reservation is not. We'll have to report it to the Supreme Court. We'll have to ask the RG to report that if these associations are not doing it and violating it, take
Lord,
action.
Association itself has to dissolve.
Senior counsel Siddharth Mridil is the amicus curiae in this matter, my lord. Supreme Court appointed amicus to look into all those complaints. They can also write to.
Monday is the last
Monday
day
is
for
the last
filing.
date.
They'll,
Fauzia Rahman's case, my lord, the Supreme Court has appointed senior counsel Siddharth Mridil to.
the problem is
I'll ask
How
the
is
chairman,
Monday?
senior
they
committee.
issue the calendar of events 2 days before or 3 days before.
Then
As lawyers and as association, you have to comply.
21
with
days not
that.
followed, my lord. I've sought for quash picking.
Lawyers cannot be doing this.
Number also, my lord.
2:30.
Another 10 minutes, I'll give the number. Sir,
Monday, my lord, the matter is pending, it is GM risk.
Madam,
State party.
there are GM rest classification which has happened wrongly. That is why many of them have been reclassified. If it's surface A matter, we don't have jurisdiction. Surface A matter will go to GMDRT. So that is why it will go before the concerned court, Kodi. Sorry? You know? What is urgency? Appear. Appearance is urgency. So? Kodi, Bharat. Just a moment, please. Kodi.
My lords, 250, petitioner is aged about 82 years. Lordship was pleased to give a date on 18, 11/18. That day the was objection of office objection has been complete. Next week, any date may be.
Fresh matter, office objection, you are complied now.
Complied.
Next week on date.
Next week.
My lords, fresh matters for the properties which have been conducting, my lords. 250 shops has been demolished, my lords, for which we are conducting a peaceful protest, my lords. For we have given a presentation before the concerned police.
Who has demolished the two?
The GBA, my lords. GB has demolished, and we are conducting a peaceful protest, my lords. For
Serve it on them.
served, my lords.
Monday.
Lords, fresh matters. It may be taken 2:30,
Lords,
my lords,
without
because
taking-
tomorrow.
Not 2:30. Serve it on them Monday.
Lords, without taking any permission, Lords, there's a protest which is happening, Lords. I've given a complaint to the police. Police are, without taking any permission from the concerned authorities, municipal authorities, an ongoing protest has been happening from almost 15 days. I've given a complaint to the police, my Lords. It's just beside the national highway, my Lord.
Monday, Tuesday.
Monday, my Lords.
ಯಾವ್ದಮ್ಮ DRT matter, post before the consent. ಅಲ್ಲಿಗೆ ಮೂವ್ ಮಾಡಬೇಕು ನಾವು ಡೇಟ್ ಕೊಡಕ್ಕಾಗಲ್ಲ for that court. You'll have to move it that post before the consent court, you will have to move for the date.
There is a stay, but still they are not. Anyway, please.
We can't give date for the other court.
My lordship, petitioner has not made a party and taken the stay before the matter, before the court, my lord. And the bank has ordered to take the
It's
possession
a
of.
pending matter.
Yes, my lord. We file.
Bank is ordered.
Bank loan ಇದೆ madam.
Surface matter.
Service matter.
ನಮ್ಮ ಮುಂದೆ ಅಲ್ಲಪ್ಪ ಅದೇ ಹೇಳ್ತಾರೆ ಅದೆಲ್ಲರಿಗೂ ನಾವು surface is a different court. Please move there.
My lords, this is LOC matter, my lords. In the previous date of hearing, my lords, you have ordered to produce a report of medical report of my petitioner's wife, my lords. I have produced a report and all, my lords. The AGI has not at all produced a report from the medical.
In what matter is this?
My lords, it is a LOC matter, my lords. LOC, my lords.
LOC matter.
Lookout circular.
Monday though.
One submission is, my lords, the protest is tomorrow, my lords. I have already served.
Matter cannot be taken up at 2:30.
The protest is tomorrow, my lords. I already served the copy for the other side. In this 2549.
You can't come, protest is tomorrow and today you can't come. They can't get instruction.
They have served the copy yesterday, my
You
lords.
come on Monday. Yes.
Fresh matter, my lords. Objections are complaint. Any day next week.
Yes. Should remind. Krishna.
42, my lords.
Hmm.
Senior able to appear.
For whom are you?
I'm appearing for petitioner, my lord.
Have you informed the respondent?
Yes, ma'am.
42 at the request of counsel for the petitioner released on 30th September.
My lord, serial number 54, my lord.
Lord, 49, my Lord.
I am for the petitioners, my lord.
54
54, 54.1 and 54.2. All the three matters I am for
for
petitioner.
the petitioner. Have you informed the respondent?
I have informed, my lord. I have informed.
54 at the request of counsel for the petitioner released on 29 September.
Lord's interim order may kindly be extended in
Interim
all three
order
matters.
earlier granted is extended till next date of hearing.
My Lord, 49, my Lord. I'm representing the first
40?
49, my Lord.
My lord, they have informed me, my lord.
Other side is there.
ನೀವ್ಯಾರಿಗೆ?
I'm first respondent.
And for the R2s,
First
For the
respondent Krishna
petitioner.
Kishore, yes.
Next week, immediate. Statement of objection.
Next week ಅಲ್ಲ ಅಜ್ಜನ್ ಆದ್ರೆ it will go to September.
there's a pending, so next week one date may be fixed, lordship.
ಇವತ್ತೆಲ್ಲ ಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತೀವಿ.
For senior judge ಅಂತ ಬಂದಿದೆಯಾ general order. So this is that matter. We are not inclined to grant adjournment last time also.
ಇಲ್ಲ ಇವತ್ತು ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದು ಪ್ರಾಬ್ಲಮ್. ಅದರಲ್ಲಿ ಕವರ್ ಆಗುತ್ತೆ ಅನ್ನೋ 50% ಕೊಡಬೇಕು ಅಂದಿದ್ದಕ್ಕೆ ಹೆಡ್ ಆಫೀಸ್ ಬರ್ದಿದ್ದೆ.
You have interim order ಅಲ್ವಾ?
Yes, my lord, there is interim protection, my lord.
49 at the request of counsel for respondent number 1 released on 15 September. Interim order earlier granted is extended till next date.
Earlier in the end of this month, September would be very long.
Madam, every date we have 150 to 200 matters already listed, and every day there are 60 fresh matters being filed. It won't reach. Now you have an interim order, it's fine. Next.
60, your lordship, I'm appearing for petitioner requesting.
Serial number
60.
60.
My lord, one submission, my lord.
Huh?
This is pertaining to Bannerghatta Tiger Reserve, my lord. Their lease has been expired already. They are challenging they got a stay on my 34 notice.
You are opposing.
I am opposing, my lord.
Sorry, madam.
because
No,
the lease has been expired for two.
mentioning oppose, ashte sir. Yes.
Lord, serial number 66, and for the petition,
Hmm.
short accommodation, Lord, senior counsel.
Have you informed the respondent? 66 at the request of counsel for the petitioner released on 29 September.
72 to 77.
77. Huh. 77.1 notice ಆಗಿಲ್ವಾ? ಮತ್ತೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿದ ನೋಟಿಸ್ ಯಾವಾಗ ಆಗುತ್ತೆ? 77.1 issue notice to the respondents written by 29 September, released on 29 September.
Lord, I appear in item 17, Lord, if I may mention. Item 17, Lord.
70.
70, Lord. My instructions are to withdraw this petition, Lord. I am for petitioner, Lord.
So you're filing a memo?
I filed my wakalat, Lord, today.
Your instructions to withdraw, are you filing a memo for withdrawal?
I will file, Lord.
File a memo. Memo for withdrawal filed, dismissed as withdrawn. File it before at 1:30.
I will file.
My lord, 78.
ನಿಮ್ದು ಏನಮ್ಮ ನಿಮ್ 232 first list to second list, it's
No, this is not the waste matter, my lord.
is not the waste matter.
No, my lord. 78. 78.
This is a good matter.
It's a good matter. 78, my lord. These are batch matters, my lord. No, advertently, my lord. 78.1. It's a cooperative society matter that's been linked to these matters.
This
These
is
are,
the
yes, my lord. This needs to be de-linked, my lord. I have some urgency. It's a fresh matter. I need to move it before the appropriate roster, my lord. My property is being auctioned. I'm only a guarantor. It has nothing to do with the other matters.
78.1 is wrongly connected.
Yes.
78.1 de-link and post before the appropriate bench.
So grateful.
My lord, one small submission in this matter. Serial number 89, my lord. You know, the sixth respondent, contesting respondent, is on a pilgrimage, he is out of station. And I am the petitioner. I had moved the court. He is sought for a short accommodation. It's a very small matter, my lord. Kindly next week or week after. My lord, it's a senior citizenship matter. An old lady who's been dispossessed. I can't say much, my lord. I'm sorry.
Every day we have more than 150 matters next week.
I'll take my chance if your lordship can accommodate. ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ
It won't reach unnecessary to be listed. That's why we want to reduce it to 100 so that 100 matters we can finish.
I completely understand. Week
So
after
that
next, if your lordship can.
Request is made on behalf of the council for respond number 16 September. Interim order idea?
No interim orders.
16 September.
One humble submission, Lord. My lordship, serial number 93, my lordship.
90. Yes.
There for the impleading applicant, Lordship. Senior counsel engaged matter, my lordship. There's some inconvenience is unavailable today.
Have we informed everybody?
Yes, my lordship. Petitioner, my lord.
93 at the request of council for
Impleading applicant.
impleading applicant released on 16 September.
Grateful.
May I make submission?
108. Withdrawal. 108 memo for withdrawal, dismissed as withdrawn.
Please.
Yes. Represent the state in the matter.
My lord, I appear for petitioner's counsel, my lord.
Yes, Mr. Shyam.
May I make one submission before my learned friend starts, my lords? In spite of me bringing to my lord's notice that they have erected the hoardings, my lords, till today morning 8:27 they have not removed it, my lords. In spite of my lords taking cognizance of the matter, morning 8:27 when my officers have.
Shyam, why do you do this?
My lord,
when
my lord,
matters are pending for the
I pointed out in the.
My lord, I may be permitted to make submission, my lord. My lord, what happened is, some third
bottom, my
parties
lord, should
not
point
in support of the event, they have posted, my lord, that banner or holding, my lord. It is not that the organizers have done. They for their, my lord, support, they have done it on their own. For that we are not responsible.
Then you are not in control of your people. How will you be in control of this procession?
It is all, my lord, the third parties who are in support of this event, they are doing it. My apologies, my lord. It is not from the organizers at all. Therefore, my lord, our petition is nothing to do with that.
Control them. How will you control them during the
tomorrow they'll come and say it was not the organizers who
You are
perpetrated.
going out on the limb. You are taking the risk of everything. ಆಮೇಲೆ
So
ನಾಳೆ
far
ಅವ್ರು
as
ಮಾಡಿದ್ರು ಇವ್ರು
event,
ಮಾಡಿದ್ರು you'll
event,
be in
my lord,
trouble.
law and order, my lord, we will fully cooperate. We will, my lord, abide by the reasonable condition, whatever may be imposed by this honorable court, my lord. Completely, we are at the hands of this honorable court, my lord, because we don't have any other, my lord, remedy at all. Therefore, my lord, for this, my lord, I sincerely apologize,
Taking
because it is not the mistake
I've
of the
given him an
organizers at all.
alternative
Third
route.
parties have, my lord, posted it.
We
They
suggested
can
an
take action
alternative
against
route, which my
those
lords
who,
also
my lord,
wanted them to. They have not come back on that.
See, if it was a religious,
No, we are not even,
accept
we're
it,
not,
but
we're not
not for
even asking them
Independence
to stop the event at all. They've already held 2 events.
why
We are
an
not coming.
alternate
No,
route,
really,
Mr.
there are hospitals. We have given the reasons in our impugned order also. Movement of ambulances and other emergency vehicles will be an hindrance if this is what it is. So, and in the evening.
It is a very wide road, my
Even
lord.
an
There is a
alternative way.
photograph also, my
It's a
learned
little
friend will
longer road.
place it on
It's
record.
not even a shorter
You
road
can
which
kindly
you have
see the
suggested.
route proposed by the petitioner. It's a wide
ಹಠ
road.
ಹಿಡಿದು
It's
ನಾನು
not
ಇಲ್ಲೇ
a narrow
ಮಾಡ್ಬೇಕು
road.
ಅನ್ನೋದಾದ್ರೆ and the
Have you seen that routes which have been suggested? Any
But
other
that
alternatives available?
well, alternative
and
route
the
they have
people whom they are
suggested.
saying
But-
they are accused in my
my
charge
lord,
sheet
my fundamental,
for
my lord,
for being vigilantes and other things.
my lord, that cannot be a ground to celebrate my lord.
It will be a ground. Why will not
Independence
it
Day,
not be a
You
ground?
have made your submission. Let him
Sorry,
make his
I'm
submission.
only
If
agitated
you,
by the
both of
fact.
you keep on interrupting
sorry,
each
I'm
other,
sorry.
then we'll leave you
I'm
to
sorry,
do it. Go on.
Sorry.
One by one. Let's
Sorry.
have some decorum. Yes, Mr. Shyam.
Lord, it is my fundamental right, madam. I am completely at the hands of your lordship, my lord. I don't have any other remedy at all. Only writ court can protect my interest. My lord, under Article 19(1)(a), B, and D. My lord, it is my fundamental right to celebrate Independence Day. And my lord,
No,
for that,
we
my
are,
lord, state.
nobody is coming in the way of doing that. What they
No,
are
my lord, their
suggesting is
endorsement
a different
says
route.
the permission is rejected. Not all that we
No,
prayed
there is
is,
a different route that they are suggesting.
Lord,
In a longer route, you will get more time.
no, my lord, it is a highway. In fact, it is a highway what they are
What do you
suggesting, Lord. And what
What
we
is the
have
suggestion
requested
here?
is a wider road. It is not that narrow road. Not only their grievance, kindly see the endorsement. They say sensitive area,
What is the
Shantimanga.
green? What is green and what is red?
Route, my lords, is suggested by the state.
ಕಾರ್ಯಕ್ರಮ ಆಯೋಜನೆಯಿಂದ ಕಾನೂನು ಮತ್ತು ಸುವ್ಯವಸ್ಥೆಗೆ ಧಕ್ಕೆ ಉಂಟಾಗುವ ಸಾಧ್ಯತೆ ಇದೆ.
Short form, lords.
This is the reason for rejection.
In fact, my lords, in the green route, my lords, there are 2 hospitals, my lords.
Where is green? Am I blind? Colorblind. Green.
My lord, even photographs of the route is also there, my lord. My learned friend will produce it for your lordship's perusal. Ritik, ಅದು ಸ್ವಲ್ಪ ಕೊಡಿ ಆ ಫೋಟೋಸ್ ರೋಡ್.
What is this yellow?
Lords,
Yellow ಏನು?
subsequently,
ಒಂದು green ಇದೆ.
please, my lords.
Green is what they have suggested. Red is what you want to do.
Please, my lords.
What is this yellow?
Alternative routes, my lords.
One more alternate route. And the blue is also an alternate. Red is what you want to
Red
do.
is what we
Yes, my lord. It's a very wide road. Photographs are there, my lord. My learned friend will produce. Not that it is very narrow road, congestion ಇದೆ, one way. No, it is a wider road. My lord, law and order, my lord, always, my lord, it is the state's, my lord, responsibility. My lord, with the great respect, my submission is this, my lord.
For Independence Day, we won't agree for law and order.
Yes, my lord, that is what. It is a peaceful celebration of our own independence. And if they have any issue regarding, my lord, security issue or the law and order issue, they may deploy even central forces. They can
In
take
fact,
that.
the hoarding is seen, my lords.
My lord, he is harping on holding, my lord. There is no point because it is not done by
No,
the.
no, no. Let me complete my submission.
Yes.
Nothing about independence is stated in the hoarding. ದಯವಿಟ್ಟು ಓದಿ ಅದನ್ನ.
ಅಲ್ಲ, ಯಾರೋ
Measures
banner
read
ಹಾಕಿದ್ದಾರೆ.
ಹಿಂದೂ ಜಾಗರಣ ವೇದಿಕೆ ಮೈಸೂರು ಮಹಾನಗರ ಸಭಾ ಅಖಂಡ ಭಾರತ ಸಂಕಲ್ಪ ದಿನ ಬೃಹತ್ ಪಂಜಿನ ಮೆರವಣಿಗೆ. Not a single letter about independence.
ಅಖಂಡ ಭಾರತ ಸಂಕಲ್ಪ ದಿನ ಅಂದ್ರೆ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಡೇನೆ ಸರ್.
ಸಂಕಲ್ಪ ದಿನ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಡೇ. ಸಂಕಲ್ಪ is when you are making a oath.
If this is the reason, I am unable to understand. It is a celebration of Independence Day. Your lordship may record my
Nothing
submission.
is stated about Independence Day in the hoarding is what I am trying to submit.
My lord, my request at annexure page 17, my lord, annexure C, page 17, we have specifically requested ಸ್ವಾತಂತ್ರ್ಯೋತ್ಸವದ ಪ್ರಯುಕ್ತ ಅಖಂಡ ಭಾರತ ಸಂಕಲ್ಪ ದಿನ ಪಂಜಿನ ಮೆರವಣಿಗೆ ಅನುಮತಿ ಕೋರಿ. Page 17, my lord. These technicalities may not come in the way of my lord writ court to.
So you are having 100 people. The limitation is for 100 people.
That's what they say in their representation.
100 people cannot create any jam or anything.
No, I'm not on the aspect of jam or anything.
They don't want
only
to.
two aspects.
So you said ambulances
Yes,
cannot.
no, only two aspects are bothering me.
Cannot be.
One is with respect to movement of thing, any emergency it happens. And second, this since
How long will this last?
they have to
Lord,
say.
it is a
They
moving mob, my lord. It is a route march.
6 ಗಂಟೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಅಂತಿದೆ, ಎಂಡಿಂಗ್ they have not
ಅವರು
indicated in
ಪಂಜಿ
there.
ಹಿಡ್ಕೊಂಡು ಟಾರ್ಚ್ ಲೈಟ್ ಹಿಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರ್ತಾರೆ. ಅವ್ರು ಹೋಗ್ತಾರೆ.
So from what time to what time is it, Mr. Sham? 6 o'clock to?
Lord, it is.
It starts from 6, my lord.
Starts from 6 and ends at
Yes.
what time?
My lord, it will assemble at, my lord, the ground, the other place where, my lord, a event is there.
How long is this?
Annexure C.
How
gives-
much is this distance?
Annexure
from,
C gives a different timing. Annexure C
that is
says
why we are asking.
8 to 9:30.
What is the distance from point A to point B?
8:30, my lord, is the 8:30 is, my lord, is the
What
stage
is the
program.
distance?
4 kilometers is what my officer says.
4 kilometers.
Yes, ma'am.
4 kilometers maybe around
At
1 hour,
Annexure
1
C,
and a
they
half
say,
hour.
Annexure
1.5
C,
hours, my lord. That is what. 6
Annexure
to
Annexure C,
8,
they say 8 o'clock
in
to
between the march
9:30
will
p.m.
go. And, my lord, then
We are fixing the time.
I'm only indicating
So
what
6
is there.
p.m. to 7:30 p.m.
your lordship may say 8 p.m. 6 to 8.
4 kilometers ಎಷ್ಟು
ಅಸೆಂಬಲ್ ಆಗಿ ಹೋಗೋದು ಮತ್ತೆ
you're
ಆಚೆ
walking or
ಅವ್ರು
crawling,
ಹೇಳ್ತಾರೆ
you're
ಕಂಟೆಂಪ್ಟ್ ಆಗಿದೆ.
walking.
Then state will come and say contempt ಆಗಿದೆ, violation ಆಗಿದೆ.
So 100 people, 6 p.m. to 5:30 p.m. to 7:30 p.m. In the light, when there is a little more light only, you finish it. So
Very well.
5:30 to 7:30 during the light, 2 hours, 100 people is what they only said. 100 people is not a big issue.
My worry is, my lords, the people whom they are suggesting, they are known antisocial elements.
You take action if they
I have
violate.
proof-
We are
I've-
undertaking. We have given
I'm
the
only,
details.
I'm only showing my concern, my lords. Let me learn it from.
Take your concern. They have given their undertaking also. Both of them will have to balance.
Of course.
It is not because you said something that it cannot happen.
Of course.
We have to balance. The balancing
The reason
is,
why we suggested the alternative road in the same vicinity from point A to point B. It is not that but their insistence on a particular road where there is some sensitivity, and as I indicated,
sensitivity we won't.
as I indicated earlier, lords, this is an alternative road for us also to have our men and thing deployed and to have a bandobast.
For Independence Day, we
Of
won't
course, we are
agree.
not. That's the reason my first submission was we are not even coming in the way. We are only suggesting an alternative road if they can take it.
Where is that affidavit you have filed?
It's not an affidavit, not
It is not affidavit. List of the organizers along with their Aadhaar card and details.
That is already placed.
My charge sheet says all these are accused.
Mr. Sham, we are recording your submission.
Yes, my lord.
So it's up to you.
Lord, in the my yesterday, my lord, during the course of hearing, I have produced one coordinate bench order where, my lord, the organizers were asked to give a bond before the Tahsildar. Your lordship may
Which one you want?
impose similar conditions.
Bond is one part. Bond is only money. If
Yes,
anything
my lord.
goes wrong, you are
I'm
responsible
saying,
for
my
it.
lord, ultimately, it is a commitment given to the law enforcement authority.
This we are going by what the additional advocate general is saying, that if there is a possibility, because the allegation is not about anybody else, allegation is about your organizers only. So that
Lord,
is why,
that my lord falls
coupled with
under
the fact that you did
privilege,
not have control over people who have put up the banner,
that, my lord, in
So
support of they
the
might have, my lord, we are
liability
not.
would be theirs. Petitioners are before this court seeking for the following leaves. The petitioners, the petition number 1 is a social and claims to be a social humanitarian non-profit service organization with petition number 1 being one of its office bearers. The petitioners wanted to conduct a procession from RMC Ganesha temple to Dodda Gadiara circle in Mysore on account of the on account of Independence Day celebrations. The petitioners.
But thereafter, one stage program is there, my lord. That is that
Sorry?
after the march, there will
Program
be
ಎಲ್ಲಿದೆ?
ಅದು ಆಂಜನೇಯ ಟೆಂಪಲ್ ವಟಾರದಲ್ಲಿದೆ. Annexure C ಅಲ್ಲಿ
ಏನು ಹೇಳಿಲ್ಲ ಸ್ಟೇಜ್ ಪ್ರೋಗ್ರಾಮ್ ಬಗ್ಗೆ.
ಇದೆ. ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಒಂದು to remember and my lord they pay respect to for the freedom fighters and my lord the struggle to remember the.
Where is the stage program?
My lord, it is at Anjaneya Swami Devasthana, Annexure C, page 16, my lord, last portion.
You are reaching Dodda Gariya circle. Ali temple ಎಲ್ಲಿದೆ? We don't see anything in the map saying that there is a temple there.
Lord, that will the march will go to that place only.
What we know, Mysore Dodda Gariya circle hatra ಬೇರೆ ಏನು ಇಲ್ಲ, it's an empty land.
ಅಲ್ಲ, ಅಲ್ಲಿಂದ ಈ ಗಣೇಶ ದೇವಸ್ಥಾನದ ಆವರಣದಲ್ಲಿ ಈ ಸ್ಟೇಜ್ ಪ್ರೋಗ್ರಾಮ್ ಇದೆ.
ಎಲ್ಲಿದೆಯಪ್ಪ ಅದು? Where is that location? Once you reach Dodda Gariya circle, you have to disperse.
No, my lord, it is in the Anjaneya Swami Deva temple, Kote.
You are starting from Ganesha temple.
Yes, my lord.
And ending at Dodda Gariya circle.
Yes, my lord. There nearby that, my lord, that temple is there, I am told.
Where is that temple here in this map?
Kote Anjaneya Swami temple.
There's a map which
You are familiar with Mysore?
I'm not.
I am also, my lord, not that great.
Dodda Gariya circle ಗೊತ್ತು. Straight road ಹೋಗುತ್ತೆ.
One of the main prime location.
And in this map also you are not shown where it is.
But I am told, my lord, it is nearby only, walkable distance. Just. ಅಲ್ಲಿಗೆ ಹೋಗಿ ಅಸೆಂಬಲ್ ಆಗ್ತಾರೆ.
The police have not disputed. Permission was granted.
Permission. There's no permission according to me. Permission illa.
You are before us only for this.
Yes, only to this extent.
Walk or.
Can't go beyond that.
To the Dodda Gariya circle.
No, my lord, what happened is they have only rejected the route march. They have not, my lord, rejected the public gathering, public program.
You are before us only for that route map.
But incidentally, my lord, it is a continuation only, my lord. Therefore, Lord,
that if you have taken the permission, that is not subject matter of this.
I don't have any instructions from that.
Have you got permission for that?
They have not produced anything.
They have not rejected our request for security for that program.
Nor have they given permission.
Have you got permission?
No,
is what this
there is nothing concept called permission, my lord. It is only giving security.
Then you take your risk. If you say that any.
No, my lord, I am requesting.
You can't make that kind of submission.
My lord, I am requesting. It is a continuation of the program, my lord. And
we are only having it till Dodda Gariya circle. That's the march. Dodda Gariya circle.
My lord, there is
an application has been made for grant of security during the said march. The respondent police, wide audited 6/8/26, have rejected the permission on the ground that there may be a communal tension which could be created along the route which has been indicated. There are hospitals. The movement of vehicles could be impinged. Apart from traffic flow being adversely affected. It is in that background that the petitioners are before this court seeking for the aforesaid relief. The celebration which is supposed to be held by way of this walk/parade is on account of Independence Day celebrations on the 15th of preceding the 15th. It's today evening, Allah?
Today.
On the eve of the Independence Day on 14th of August 2026. Such being the case, when Independence Day is supposed to be celebrated, there cannot be any issue that could be raised as regards communal tension or otherwise. Independence Day being is required to be celebrated by every citizen of India. Insofar as the contention of the learned additional advocate general that there could be a traffic, the procession could affect the traffic adversely. The submission of Sri Aruna Sham, learned senior counsel appearing for the petitioner, is that the procession will commence from 5:30 a.m. and end at 7. It will commence at 5:30 a.m. from RMC Ganesha Temple and end at 7:30 p.m. at Dodda Gadiara Circle. And even as per the letter which had been submitted, there will be only 100 persons who would be participating in the said procession. Such being the case, when only 100 persons are participating, the question of any particular impeding of the traffic flow over a 4-kilometer walk cannot be accepted. Of course, the said procession would have to be done in an orderly manner with only around 5 people in each file, in each row, so that the road, the rest of the road is available for easy flow. The procession being a moving one and not being restricted or stationary at any particular place, and the procession being over a period of 4 kilometers, the adverse impact on traffic, if any, would also be spread over the 4 kilometers and spread over a period of time, which cannot be such that the celebration, the celebration of Independence Day by way of the procession can set to so adversely affect the traffic flow that the permission is to be rejected. The last submission made by Sri the Additional Advocate General is that as regards some of the organizing members, there are FIRs which have been registered.
Charge sheets also.
And charge sheet filed, and there may be a possibility of them involving in unlawful activities and or activities which could disturb the public peace. Merely because proceedings have been filed against certain persons where charge sheet have been filed does not mean that those persons cannot be allowed to participate in the Independence Day celebrations. It is in that background that the learned senior, Shri Aruna Sham, learned senior counsel, had submitted that the organizers will take all responsibilities in respect of the said procession, and they would ensure that there is no untoward incident which takes place. A memo has also been filed on 12/8/26, giving the details of 9 of the organizers who would be responsible for the procession to be conducted in a peaceful manner. They said names are reproduced hereunder for easy reference. Along with the said memo, the Aadhaar card of each of the said persons is enclosed, providing the details of their address, etc., which would always be available with the respondent authorities in the event of any action to be taken as submitted by Sri Aruna Shamla and Senior Counsel if an unlikely untoward event were to happen. In view of all the above facts, being of the considered opinion that Independence Day, that all citizens would be required to celebrate Independence Day, and nobody ought to be prevented from celebrating the Independence Day. This court passes the following order. Writ petition allowed, a certiorari is issued. The endorsement dated 6/8/26, bearing number so and so, issued by respondent number 2 at Annexure A, is quashed. Respondents are directed to provide necessary security, and respondents are directed to permit the petitioners to conduct the Akhanda Bharata Sankalpa Dina and hold a torchlit march, walk, procession from RMC Ganesha Temple commencing from 5:30 PM on 14th August 2026, ending at 19:30 hours on 14th August 2026. By providing such security as may be.
Dodda Gadiyara minutes. At Dodda Gadiyara.
At Dodda Gadiyara.
My lord, that prayer,
The
my lord,
Gadiyara
we
circle.
have requested, my lord, even our prayer says, my lord, for the public program. Kindly see page 12, prayer, my lord. It is not that.
That
my
is
lord,
what we are looking at.
Yes, my lord, prayer, kindly see, to conduct the torchlight
You
march.
conduct stage
to
program
conduct
at
state
Mysore
program.
city antide.
ಹೌದು.
If you conduct a stage program, whatever permission if you have taken, you can conduct it.
Yes.
Insofar as
In the guise of my lord's order, they should not do that, is what I am submitting.
we'll mention this. Insofar as the stage program to be conducted, if the petitioners have obtained necessary permission for conduct of such stage program, they would be entitled to do so. It is made clear that this order does not in any manner permit any stage program. Hand delivery ordered. Hand delivery bharat, but learned AG is directed to inform the concerned authorities about operative portion upload ಮಾಡ್ಬಿಡಿ ಇವಾಗ. The respondents are directed to act on the operative portion of the order without insisting on the entire order. Learned AG is directed to inform the concerned authorities about the above order by email and telephone.
Please.
We are grateful, my lord.
WhatsApp ಹಾಕ್ಬೇಕಾ? Please maintain proper peace and ಇದು don't.
We will do that. It will be, my lord, peaceful march. Great.
Yes.
Government order challenge annex area, my lord.
What
Your
is the order?
recommendation?
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಪ್ಪ?
The penalty with the
Government order.
Not
Annex
accepted.
area.
AGA for respond number 1, issue notice to respond number 2, connect with one series of matter. Connect with so and so. Yes.
Is applied for a grant of land alternatively. Earlier, it was ordered in single window system in the year 21.
Learned AGA for respond number 1, 2, 4, 5. Udyog Mitra yaru?
Sukrita R.
Sukrita R for respond number 3. Mr. Vasudev for respond number 6. Counsel for the petition to furnish 2 sets of the petition along with annexures on the said counsel for granted 2 weeks time to obtain instruction, make their submission, released on 10th September.
Please.
Yes, Mr. Atik. Yes.
My lordship, this is the third writ petition which has been filed.
Third writ petition.
My lordship. The third writ petition is filed by the petitioner requesting my lordship to conduct the proper examination on the technology which has been used for controlling the nervous system, my lordship. This is the case which is based on Havana syndrome, my lordship.
Then you can.
Now, my lord, lordship, may kindly see para 5 and 6. He himself says that he has no personal interest, so the writ is not maintained.
This is not personal interest. You are not alleging anything.
Sir, my lordship, petitioner is one of the victim, my lordship.
Where have you said that?
In prayer, my lordship. In prayer.
Prayer ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ.
It is further submitted that he has no personal pecuniary individual interest. Para 5, first line.
In prayer, my lordship.
Similar petitions are.
Where is it that you are affected by it?
The petitioner.
So-called.
It has mentioned in.
Because the para number, Mr. Counsel, do it fast.
Annexure C, my lord. Annexure E, my lordship.
Page?
Page 66, my lordship.
This is Ayurvedic treatment for tinnitus.
Because of continuous ringing of ears, he has got tinnitus, my lordship. Here the thing is, my
What is he
lordship,
working as?
he was earlier working in software AG, my lordship, which is in Electronic City. Since 2016, he is not working, my lordship, because of this. My lordship, in previous writ petition, Honorable Karnataka High Court has given order to Electronics and
Where is the
IT
earlier order?
Ministry, my lordship, to conduct an inquiry.
Page?
Page number 58, my lordship. The order has been mentioned as Annexure B, my lordship.
58.
58, my lordship.
Along with the double agent.
Now, my lordship, Annexure.
No direction which has been issued. There's no direction which has been issued. That was for representation to be considered, that's all. Not, no direction. Yes, which is the next order?
Annexure C, my lordship. The letter has been sent to the petitioner that they have conducted an inquiry that there is no such technology which has been used, my lordship. But the thing is, like, they have not contacted the petitioner, my lordship.
Even at page 33, my lord, in that reply by the Union of India, Ministry of Communication, para 10, they have said, where the petitioner has asked to stop the agencies. The petitioner has completely failed to establish what loss has been caused to him. And by which
Do one thing,
agencies.
get him examined by NIMANS for any nervous issue. If that report, on the basis of that report, let us see what happens. Otherwise, this considering the representation third time is coming,
Yes,
no
ma'am.
purpose would be served. Being of the considered opinion that the National Institute of Medical Sciences bracket NIMANS would be a necessary party in view of the
They
directions
made
proposed
demands
to be
as party.
issued.
Demands is already a party.
NIMANS party there.
Immense is respondent number 8, my
Oh,
lordship.
yeah, National Human Rights Commission. Okay, NIMANS is there. And AGA for respond number 1, 2, 3, 4.
8, my lordship.
5, 6, I have instructions of your lordships. 5, 6.
MN Kumar for 5, 6. National Human Rights Commission.
There might be a separate council minutes, I will communicate. There might be a separate council for their commission.
Government to serve the standing council for respond number 7. Sri Madhusudan Rao is directed to accept notice for respond number 8. Council for the petition to furnish 2 sets of the petition along with annexes on the said council. The director, respond number 8 is directed to examine the petitioner in respect of the allegations which in respect of the contentions which have been taken up in the above petition and submit a report before this court. It is made clear
Yes, my lordship.
that the said report submitted by NIMANS would be taken into consideration by this court to pass further orders, and any further submission contrary thereto will not be entertained.
Please, my lordship.
The petitioner shall appear before the director NIMANS on 19th August 2026 for such examination. Report to be submitted by 25th August, relist on 25th August.
Oblige, my lordship.
Public.
Appearing on behalf of the petitioner, well, as this matter had come up yesterday, there's a matter with respect to the senior citizens. There are 2 properties that are involved, Millet.
Sister and brother.
Please, Millet.
You drafted the document.
The petitioner.
You
Millet.
signed it as you have drafted it.
The draft was prepared by the petitioner.
Much are you willing to deposit?
Millet,
What's the
if I
value
may-
of the property?
I got instructions, Millet.
ಹೇಳಿ.
The 1 ಎಕರೆಗೆ ಅಲ್ಲಿ 48 ಲಕ್ಷ ಇದೆಯಂತೆ ಸ್ವಾಮಿ.
ಇವಾಗ ಇದೆ
Market value. But my instructions are that, Millet, if I may make my submission insofar as my instructions. one acre 8 guntas ತನಕ ಇವ್ರಿಗೆ ಬಂದಿದೆ ಸ್ವಾಮಿ.
ಇವಾಗ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
My lords, the petitioner is saying that he is ready to abandon his claim insofar as the mother, whatever the mother has executed the release deed, he is ready to abandon his claim. But insofar as the sister's part is concerned, my lords, sister has not approached the AC, and when she executed the release deed, she was not even a.
For respond number 1 and 2, issue notice to respond number 3 and 4, returnable by 28th September. The submission of the petitioner, learned counsel for Sri Nagesh Vinay, learned counsel for the petitioner on instructions.
On instructions, please.
Of the petitioner is that the petitioner will not, is not challenging, gives up the challenge in respect of item number 1 of the scheduled property.
Please, my lords.
Which is the item number?
Item number 1, my lords. My lords can find the release deed executed by my mother at annexure C.
C.
Annexure C ನಲ್ಲಿ, my lords, more particularly at page number 46. HP ರವರ ಮಾಲೀಕತ್ವ ಹಾಗೂ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳಿಗೆ ಒಳಪಟ್ಟಿರುವ ಸ್ವತ್ತುಗಳು. This is what my mother released in favor of me, my lords.
Gives up his claim in respect of release deed executed by respond number
4, my lords.
4 in favor of the petitioner, namely the land measuring 13 guntas. Measuring 13 ಎಲ್ಲಿದು? What is the extent? Measuring 17.08 guntas.
Please, my lords.
In survey number. No, A schedule is HP Padma.
And that is executed in favor of my sister.
So it's not item number 1, it is B schedule.
B schedule, my lords.
Namely 13 guntas in survey number 136 bar 2 and 35.12 guntas in survey number 136 bar 3 of B Vasalli Grama, Sarjapura Hobbli, Anekal Taluk. And would restrict his claim as regards.
My lords can come to page 55.
The release deed executed in favor of respond number.
Executed by respond number 3, my lords.
By respond number 3.
In favor of petitioner.
She is also a senior citizen.
No, my lords, she is not.
64 years.
No, my lords, when she executed, she was 58. I've produced.
Doesn't matter, we already held that.
Please, my lords, but she has not even approached the AC.
That is the only thing, but she is also a senior citizen. It's one application. In that view of the matter, respond number 3 is restrained from any manner alienating, dealing with, encumbering or changing the character of subject property till the next date of hearing. Process fee and copies to be furnished by end of day 17th August, failing which the interim order will stand.
May I make one submission, my lords? With respect to the submission that I made, if my lords direct, I will even get an affidavit filed by the petitioner himself. Please.
We have taken your undertaking, that's all.
I will even get a affidavit if that may be
Your
observed.
interest. That's in your interest.
That may be observed in the order.
Find it.
I'm grateful, my lords.
So the petitioner. Club this
Without the club matter, my lord, it can be taken up on 17th.
17th.
The interim
And
stay may
AGF
be
for
granted.
respond number 1 to 6, give us that one. Same order, 17th.
Stay is granted in our.
Yes. Parole, huh?
Parole matter.
And AGF for respondent released on 19th. Yes, Mr. Hegde. Mr. Counsel, you'll have to leave space for the next counsel.
Petitioner, my lord. One Marie Swamaya died on 26, 2023. He is the brother of the petitioner, my lord. She is this person is suspiciously died. After selling his property nearly worth of more than 7 crores, my lord, there are also other properties.
174.3.
Yes, my lord. Then
We have held 174.3. You have to submit it before the magistrate, and magistrate has to accept it.
Yes, my lord. My lord, because in this matter, my lord, they have sought for the they have filed a WPs to consider their representation. After that, we have conducted the postmortem and we have filed the charge sheet also, my lord.
Charge sheet has been.
charge sheet is not filed.
Page number 53.
Charge sheet, a final report.
Final report, my lord. My apologies.
Final report.
Final report.
It's
Final report
filed before
again,
the
it is for
magistrate, my lord.
To accept it.
They have to file the protest petition.
I agree, my lord. That's my particular thing is, there are 7 crores worth more than that one properties and
Yes,
all.
Mr.
It is
Hegde,
not
in
at
a
all
writ petition-
investigated.
in
I
a writ
agreed, my lord. My particular thing is, my lord, to refer the matter to the COD or
There is
CBI.
a
the
procedure
truth will-
under 174, 175, 176, now 194, 195, 196. They were not even filing before the magistrate. Now they have filed in this matter. We are lucky that they have done that. Now that it has been done, if you are not acceptable, protest memo, and then that court can direct further investigation, re-investigation, all those things.
Yes, ma'am. That
Not
liberty
before
may
this.
be given.
And AGA accepts notice for respondent 1 to 5. Petitioner is before this court seeking for the following reliefs. The submission of the petitioner, submission, madam. The petitioner claims to the wife of
Brother,
a
a
sister,
sister, my lord.
of Mariswamaya, also known as Hotel Shivanna, who had expired on
26, 23.
that you came to know. When did he expire?
The 26, 23. 26, 23.
23, what you have said here is you came to know about his expiry. When did he expire? 4 to 5 days before that. He was not
Before
eating
that,
anything.
my lord. And not intimated the death also.
So what is the date of death according to you?
The
Are you
date
sure
of
it is
death,
that?
my lord, death certificate is also produced. 26, 23.
Then I'm reading wrongly. Had expired on 26, 23. The petitioner, in furtherance of which a unnatural death report was registered. The petitioner suspected foul play on account of his properties having been sold just prior to his death, and all the valuables, including gold ornaments, etc., including those belonging to the joint family, were not traceable. It is in that background that the petitioner is before this court seeking for the aforesaid relief by quashing the endorsement issued by the police inspector that the death is natural. Learned AGA on instruction submit that post the UDR having been registered in UDR number 19 of 24, the necessary inquest has been held in terms of section 194 of the BNSS and final report submitted before the jurisdictional magistrate. His submission is that the entire procedure under section 194, 195 and 196 has been followed by the respondents. This court in so and so Manne on Madhepal has held that once a UDR is registered, the necessary consequence would have to be the filing of the final report. And once a final report has been filed, the remedies available to any other complainant, including that of filing protest memo, challenging the protesting as regards the final report, is always available to the complainant. The petitioner standing in the position of a complainant, being the sister of the deceased, could always avail of such remedy. In that view of the matter, this court in that view of the matter, it not be required for quashing the endorsement once a final report has been submitted, and this court cannot direct further investigation by the CID as sought for by the petitioner. That would be for the jurisdictional magistrate to decide on the basis after considering the reasons submitted in the protest memo. Hence, this court passes the following order. Writ petition is partly allowed. Liberty is reserved to the petitioner to file protest memo or the like, challenging the final report filed in respect of UDR number 19 of 2024, which shall be considered by the jurisdictional magistrate.
Lordship, petitioner has taken the loan from the respondent bank, your lordship. Petitioner has taken the loan from the bank, your lordship. As per the annex share page number 25, your lordship.
Yes.
It has declared the NPA, your lordship.
NPA.
Please, your lordship. As per 1,52 lakhs has to be paid as per annex share, your lord. Out of 2 crore to 82 lakhs, your lord. Accordingly, annex share, FU, your lordship, page number 67. I made a representation before the bank, your lordship. Bank, as per annex G, page number 68, bank has accepted the NPA, your lordship.
Return of original document. You want the return of the original document?
No, your lordship.
The annex L is only that.
Annex L, your lord. As per annex G, your lord, can you see, page number 68. Out of, they have fixed the date for
annex
5/11/2020, your lord.
Annex L is page 82.
68, page number 68, annex G, your lord. G, annex G. Annex G.
68.
Please.
Yes.
And 5/11/2020, they've accepted within 30 days, he has to pay 1 crore 52 lakhs, your lordship. Within 30 days, your lordship. Due to the COVID, your lordship, I'm not paid within 30 days, your lordship. After that,
when did you pay?
On 24th February 2021, your lordship, page number H, your lordship. I paid the 90 lakhs, your lordship. They accepted and they released the document, your lordship. As per annex H, your lord. After that, your lordship, even after lapse of the period, your lordship, 2.5 months, they accepted the amount, your lord, part payment, 90 lakhs has been accepted. Out of remaining 68 lakh has to pay, your lordship. After that, your lordship, they received the amount and released the document, your lordship. They are not returned the original documents, your lordship. After the, kindly see the annex share.
You paid only 90 lakhs.
Please, your lordship. Out of
that OT has expired in 2020. You paid this money in 2022.
After lapse of the 30 days, your lordship, they have considered my representation. They have released my document, your lordship. Because of due to COVID, your lordship. And as for annex K, your lordship, page number 81, your lordship.
Yes.
As I mentioned, your OTS approved on date 1 crore 58 lakhs and dated 5/11/2000. As per we are paid the amount 90 lakhs, but we are not given the original documents as survey number so and so. Due and the COVID reason, we can't pay the balance amount. Cannot come to bank, and therefore we are not paid the remaining balance amount 68 lakhs euro. So we are ready to pay the remaining amount, remaining balance 68 lakh along with the interest, your lordship. But as for annex L, your lordship, they says that you not paid the amount within period, your lordship, that rejecting the.
No, they are also saying that you have not deposited that original sale deed. That's why they can't give it to you.
Yes, but
that's why we asked you. It's a issue relating
remaining
to return of the document.
Please, your lordship. And I'm ready to pay the remaining amount, your lordship. I made a representation to remain the amount.
Bank of India. Mohammed Tahir is directed to accept notice for respond. Counsel for the petitioner furnished 2 sets of the petition along with annexes on the said counsel released on 10th September.
Until that stay has to be not
in stay
to annex LU.
The OTS, we can't stay there. If they are
After
acceptable,
lapse of the period, they
you don't
accept
have vested right. If they are acceptable, we'll see. Next.
Petition, my colleague from the petitioner, writ of mandamus direct to the, consider the representation 25/2/2025 and 24/7/2025. Regarding, I am the petitioner is a class 1 contractor. The work was completed and RA bill was also is completed. We are receiving the only escalation price.
Vishweshwara Jala Nigama Limited.
Yes.
We are a standing council here.
I'll find out.
You don't know.
Good.
Vishweshwara Jala Nigama. First time ಬರ್ತಾ ಇರೋದು ಯಾವುದು?
Find out issue notice.
AGA for respond number 1, issue notice to respond number 2 to 6,
Sir.
returnable by 29th September.
In a short accommodation.
Notice ಹೋಗಿ ಬರ್ಬೇಕು ಆ ಜನಕ್ಕೆ.
For the petitioner, my lord, the petitioner is the purchased the flat, my lord, through e-auction conducted by the HDFC Bank, my lord. And my lord, the banks forwarded the sale certificate in favor of the sub-registrar for entry in book 1, my lord. Now, my lord, thereafter several correspondence, my lord, the bank has been intimated by the sub-registrar, my lord, to saying that the instrument attracts Article 15 of the Stamp Act, my lord. My lord, the point in issue, my lord, is fully covered by the decision of the Honorable Supreme Court, my lord.
No, this, my lord, again, the distinction is, recently, my lord, I think last week, the Madras High Court has also clarified on this issue, saying that the bank should collect the equivalent stamp duty at the time of issuing the sale certificate to avoid all this confusion. Now, what happens is, my lord, Article 15, my lord, Article 15 says it is not Article 15 of the Stamp Act. It reads as, where in any other case, the same duty as conveyance 20 for the market value equal to the amount of the purchase money only, my lord. So the benefit is, my lord, it is not on the market value. Article 20 is the market value of the immovable property. But here, the amount that has been paid to the bank, on that they have to pay the stamp duty for registration. Now, my lord, the other aspect is 89(4), which says filing. Filing is we have to file it in the register. What Madras High Court has distinguished is, my lord, they said when the document is used, even if you have to get a revenue entry also, it is you have used the document. So it is only till then. It's a temporary arrangement, my lord, but we are also in a catch-22 situation because of the Supreme Apex Court judgment, my lord. We have to file it. Your lordship also has passed that order before.
You have to file it, but now, what is the filing is not a problem. What is the stamp duty leviable is the issue.
No, that they are not disputing. They just want a filing.
Filing on payment of stamp duty or non-payment of stamp duty?
On payment of stamp duty, Article 15, we are willing to collect on that if they are willing to pay and register the document.
My lord, Honorable Supreme Court says, my lord, entry in book 1.
You have the copy of the Madras High Court judgment?
No, my lord, I don't have it, my lord. I just read it.
You notified?
No, my lord.
You also have a look at it.
I'll.
Lord, AGA accepts notice for respond number 1 to 4. 1 to 4. Shri Francis Xavier for respond number 5. Counsel for the petitioner to furnish 2 sets of the petition along with annexures to the opposite counsel. Lord, AGA submit that a similar list has been considered by the Honorable Madras High Court. He seeks for a week's time to place the same on record. Yellappa next week. Released on 18th August.
Much.
Yes. Yes.
We have engaged the services of a senior counsel. He is engaged in a different court. Lords may kindly pass it over. Lords.
You'll have to file a suit if somebody is interfering with your position. Paso. Refer. You will give protection.
If you need the private protection, my lord, because there is a judgment of the High Court earlier. If for a license query, if there is some third person side interfering, you have to protect their interest.
And AG accepts notice for respond released on Monday. So even in respect of a query, private query you will be giving.
No. But with the subject to payment, my lord. But they are telling they are not willing to pay the fees, what we are quoting.
Okay, if there is, fine.
Yes.
Yes.
But the fifth respondent is facing an investigation. Multiple offences, including offences under the Buds Act. Now, the petitioner is one of his victims. my lords, he alone, my lords, has suffered, my lords, losses to the tune of 30 crores. My lords, there are multiple petitions which were filed by the family members of the fifth respondent and the fifth respondent himself, all of which, my lords, have been rejected. My lords, we have made a request, my lords.
Is there a extradition treaty with UAE?
UAE, my lords, I'm told there is an
Yes, we have.
extradition.
Any action taken?
No, Lord, the law enforcement agencies,
It is a state.
Lord, there are 3-4 possibilities. One, he must be a convict. There should be an order of conviction. 2, there must be at least an arrest warrant. There should be some action by the law enforcement agency. The government suo motu cannot extradite. Anyway, Lord, his relief, if he,
2 to 4.
if first relief is granted, second relief we will act, my Lord.
There is one, my lords, correspondence by the Ministry of External Affairs. If my lords put peruse page 34, my lords, this is an electronic mail.
Respondent number 2, 3 and 4.
Please.
Have to send the requisition to
Yes,
respondent
lords, I'm
number 1.
told they have. Lords, I'm told they have.
No?
Lords, I'm told they have.
Only the first respondent is standing. Where is this? Who is standing for the second respondent?
So if the center is there, then
You have served only the ASG's office. You have not served the AG's office.
Lords, we have served both offices.
Only ASG served antide.
But I'll serve further copies also. But for a moment, if my lord should see page 34.
Shri Aditya Singh accepts notice for respondent number 1 and AGA accepts notice for respondent number 2, 3, 4. Notice to respondent 5 is deferred for now. And counsel for the petition furnished 2 sets of the petition along with annexure and learned AGA who seeks for a week's time to obtain instruction make a submission as to the actions taken by respondent number 2, 3 and 4 in respect of the extradition of respondent number 5.
Please.
Released on 31st August.
Grateful. So grateful.
Is appointed by the Indian. Yesterday, AG has told that there's some instructions they'll take and come.
Your
First pass over.
category A and category B.
And that also I was
Where
working,
you
sir.
are working.
There-
And AG accepts notice for respondent number 1, 2, 3. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be working as a Pashka in Sri Peshkar.
Peshkar, sir, yes.
Pashkar and Madhu. Peshkar in Sri Kodandaraja Halli Anjaneya Swami Temple, Peddapalli, which is a A-grade temple situated in Kolar. The petitioner is aggrieved by the transfer orders issued on 37/26 by the additional deputy commissioner. The submission of learned counsel for the petitioner is in terms of the circular issued on government order issued on
Government
25th
issued-
June 2015. It is the Commissioner of Endowments, Commissioner of Religious and Charitable Endowments, who is the authorized authority to effect any transfer in respect of A-grade temple. The Deputy Commissioner would have only authority over grade ಅಲ್ಲ B category.
Categories.
ಇದು
Applies.
grade ಅಂತ ಹೇಳಿ ಬಹಳ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ. You should say category.
Categories.
You can't call it temple A grade, B grade, C grade. Doesn't sound good. Any religious institution would be said as category. The additional deputy commissioner or the additional deputy commissioner would have jurisdiction over B category temples. In that view, the said submission is borne out by the documents in as much as the transfer order has been issued by the additional deputy commissioner and not by the endowment commissioner. In that view of the matter, this court passes following order. Second portion, please allowed, is partly allowed.
Partly allowed.
The resolution dated 37/26, the endorsement dated 37/26 at Annexure B, insofar as the petitioner is concerned, is quashed. Liberty is however reserved to respond number 3 to take such action as may be permissible. To pass such orders as may be permissible. Yes,
Petitioner is sought for general parole, my lord.
general parole.
There is no application in this matter for the parole.
Anyway, we are dismissing it. 4 years ಅಷ್ಟೇ ಆಗಿರೋದು. And AGA for response. Petitioner wife of the détenu, CTP 16234 of 16234 is before this court seeking for the aforesaid relief. The détenu had been convicted on 5/6/26 for offences under section 302 read with 34 of the IPC for with the highest of the punishment being imprisonment for life. In SC number 163. The petitioner has filed the above petition seeking for parole on the ground of,
House repair.
house repair. Considering that the petitioner has been sentenced to imprisonment for life and has only served 4 years, 11 months, this court is of the considered opinion that it is too premature for such consideration, more so when there is not even an application filed before the authorities. Reserving liberty to the petitioner to approach this court for grant of parole after serving a substantial period of sentence, the petition stands disposed. We have more so on theory. Yes, Mr. Chokareddy.
Rowdy-sheeter notice was issued. That
Hmm.
earlier similar notice was issued by the DOSP Dodwalapuram. That was challenged by the petitioner. This honorable court issued the direction to, that is a guidelines has been not been followed, BS Prakash guidelines. That is disposed, very same reference of the similar FIRs. The second respondent has issued again the notice. That is the judgment of this honorable court 19 July 2024.
Page?
Page annexure C, page number 22. Earlier the petitioner approached this honorable court. Very similar.
That was for you to reply to the note.
That was replied, that is a pending consideration. No order was passed by the respondent number 3. Very same similar offences.
So now what has been issued?
Now there, the Subramaniapura.
Now they have issued a notice.
Again, Subramaniapura police have similar the FIRs referred in the notice. As issued
What happened to the earlier report?
More notice.
And AGA accepts notice for respond number 1 to 4. The submission of learned counsel for the petitioner is that once earlier a notice had been issued to open a rowdy sheet by the very same police.
Not very same police, that is the Dodwalapura DYSP has issued, That is 3 crimes registered in the.
By the Deputy Superintendent of Police, Dodwalapura.
Now they issued Subramaniapura subdivision.
Add why it's ordered dated 19 July 24 in WP number 14756 of 24. Set aside the said that permitted the petitioner to reply to the said notice, directing the respondent to pass necessary orders.
No decision was taken by the.
No order, passed. A fresh notice has been issued now by the Subramaniapura subdivision police as regard the very same criminal offences. Learned AGA is directed to secure instruction as to whether there are any orders which had been passed on the reply submitted by the petitioner to the notice issued by the Dodbadapura police station. The first respondent is directed to consider and implement a necessary information technology system so as to ensure the availability of all orders passed by the courts in respect of rowdy sheets, irrespective of the police station.
Yes.
So far as it relates to the person against whom a rowdy sheet is sought to be opened so that these aspects could be verified by the concerned police before issuance of any notice, avoiding these kind of multiplicity of proceedings. Released on 10th September. Please. Until then, operation of Annexure A is stayed. Mr. Anand P.
Thanks to RBI direction amendments, ma'am.
108.
Yes, ma'am.
108, learned, same order.
Order passed in other
Body.
writ petitions. Seeking interim protection, my lord.
Ravi Kumar, sorry. Anand P. So there's a challenge made to so-and-so, issue notice to, same. Connect with so-and-so.
That's okay.
The petitioner. No, this matter, my lord, is the matter where I've challenged the Annexure A, my lord, is an order passed by the Karnataka SC/ST Commission. My lord, now what happens, my lord, is I am the owner of the Schedule A property, my lord. The respondent number 2, my lord, claiming to be the owner of Schedule B property, which is a totally different property, seeks to make certain interference with my property, my lord. In 2012, my lord, I filed a civil suit and obtained a permanent injunction, my lord, against him, restraining him in respect to that property, my lord.
Yes, learned case, commission error. CST commission was a standing council.
I am not aware, my lord. I will.
AC Manjunath was there, it was changed. Well, Monday somebody appeared. So-and-so is directed to accept notice for respond number 1. Bardirಬೇಕು ನೋಡಿ ಅಲ್ಲೆಲ್ಲ. Issue notice to respond number 2.
He's on. I'll take notice as well.
See, R. Ravi Kumar, who is filed KVIT, is directed to accept notice. K. Chandramohan.
Please.
Is directed to accept notice for respond number 1. Shri R. Ravi Kumar, who is filed KVIT for respond number 2, is directed to accept notice for respond number 2. Considering that there are civil disputes which are pending between the petitioner and respond number 2.
In fact, it's disposed of, my lord. I furnished the certified copy of the judgment and decree, which is an Annexure E, my lord. Page
Considering
46.
that the disputes between the petitioner and respondent 2 are civil in nature, as regards which an earlier suit had been filed, the first respondent could not have exercised jurisdiction in respect of such civil disputes merely on the ground that respondent 2 is a person belonging to scheduled caste category.
Yes, it's also covered by
Hence,
judgment.
the further proceedings in so-and-so. The order dated 29/7/26 passed in case number 6 of 22 by the first respondent at Annexure A. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 17th August, failing which, is there KVT, no process fee.
I'll serve
Copies to be furnished to respond number 2 by end of day 17th August,
Please,
failing which.
Much pleasure.
Girish. Notice, sir. Order ಅಲ್ಲಪ್ಪ. Where's Girish? Paso.
Please, your lordship, for the petitioner, the respondent number 1, bank, my
A
lord.
bit freezing. Yeah?
Please, my lord. Upon the directions of the UP police, my lord.
Lord,
Copy serve ಮಾಡಕ್ಕೆ
yeah, who is appearing for
BS Jeevan Kumar. For
Yes,
ICC.
Jeevan Kumar for respond number 1, notice to respond number 2 is dispensed with. Petitioner is directed to appear before the cyber command on next Thursday is 20th.
Please.
After 20th, ma'am, 21st after.
Cyber command works only on 20th.
Yes, ma'am.
Yes.
I appear for the petition in this case, my lord. My lords, this is surrogacy matter, my lords. The petitioner is the intending mother, my lords.
Petitioner is the
intending mother, my lords.
Mother.
Who wants to avail surrogacy service, my lords. Now, my lords, under the Surrogacy Act, my lords, she initiated
To
treatment.
make the Union of India a party.
Yes. Because, my lords, the issue is only with the state authority, my lords. Because, my lords, she has applied, my lords, just because, my lords, after applying to the authority, she has, the surrogate mother crossed age limit fixed by the act, my lords. So, my lords, the consideration of the age limit must be in accordance with the date of application made to the authority, my lords. For that reason, I have not made
Concerned authority is the Union of India, not the state of Karnataka under the act.
It's a central act.
Please, my lords.
So this
My
relief
my
cannot
lords,
be
may I
granted.
request, my lords, to see, my lords, page number 24, my lords. It is impugned order, my lords. My lords, third paragraph, my lords. May I please read, my lords?
Yes.
My lords, ಸದರಿ ಮನವಿಯೊಂದಿಗೆ ಸಾರಿ my lords, ಪ್ಯಾರಾ ನಂಬರ್ 2, my lords. ಸಂಬಂಧ ಉದ್ದೇಶಿತ ದಂಪತಿಗಳಾದ ಶ್ರೀಮತಿ ಸೋ ಅಂಡ್ ಸೋ, ಶ್ರೀಮತಿ ಸೋ ಅಂಡ್ ಸೋ ಅವರನ್ನು ಬಾಡಿಗೆ ತಾಯಿಯಾಗಿ ಸೂಚಿಸಿ, ಎಲಿಜಿಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಫಾರ್ ಇಂಟೆಂಡಿಂಗ್ ಕಪಲ್, ಎಲಿಜಿಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಫಾರ್ ಸರಗೇಟ್ ಮದರ್ ಹಾಗೂ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಎಸೆನ್ಶಿಯಾಲಿಟಿ ನೀಡುವ ಕುರಿತು ಅಗತ್ಯ ದಾಖಲೆಗಳೊಂದಿಗೆ ದಿನಾಂಕ 17/11/2025 ರಾಜ್ಯ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿರುವುದು ದಾಖಲಾಗಿದೆ. My lords, now, my lords, annexure C may kindly be seen, my lords, at page number 15, my lords. The surrogate mother was well within the age limit when the application was made to state authority, my lords. State authority under the act, my lords, they are responsible to issue the certificates, my lords.
We'll have to just dismiss it because the appropriate authority is not made a party. You want us to dismiss it?
No, my lords.
We have told you thrice, the AGA has also said, make the proper authorities party.
Please, my lords.
And AGA accepts notice for respond number 1 and 2. Counsel for the petitioner seeks for and is granted 3 weeks time to file necessary application to implead the appropriate authority.
Grateful.
Released in September, 10 September.
My lords, appear for petitioner, my lord. My lord, simple writ of mandamus, my lord, for issuance of retail drug license, my lord. My lords, my representation is at annexure A,
For
dated
issuance of,
15/5/2025, my
for
lord.
issuance of,
Retail drug license, my lord.
you have made an application?
Yes, my lords. My application is at annexure A, my lord. Page number 16 and 17, my lord. Dated, my lord, 15/5/2025, my lords. 1 year has been lapsed, my lords. My lords, my application may be considered and appropriate
Who has to
orders may
issue
be
this,
passed. Respondent number 2, my lord.
Annexure A, my lord, one thing is, my lord, there's no acknowledgement of having submitted on the date, my lord.
My lords, acknowledgement is at annexure F, my lords. Series of documents have produced before respondent number
Page
2.
number?
Page number 73, my lord. F series, annexure F series, my lord.
Where's the acknowledgement? If it is submitted online, you should have got a number, no?
My lords, number is, my lord,
Illide.
one second.
There must be something.
My lords, page number
82.
75, my lords.
82 E acknowledgement is there.
Yes.
82, my lord.
F6. And AGA for respond number 1 and 2. Bhadravati, ZPR. BS. Sanjeev is directed to accept notice for respond number 3. Petitioner
Respondent number 3 is
before this court
Panchayat.
seeking for the following grievance.
not
The grievance of the petitioner is that the application for issuance of a drug license on 15/5/26 as acknowledged by the E acknowledgement at annexure F6 has not been considered by the respondent and processed. His submission is that whenever any application is filed by a citizen to any authority for grant of a license, the same is required to be considered and necessary orders passed within the time frame prescribed by the enactment under which the said application is filed. In the present case, the application having been filed on 15/5/25 has been pending for more than a year, which cannot be said to be reasonable. As said, this court passes the following order. The writ petition allowed, mandamus issued, directing respond number 2 to consider the application dated 15/5/25 at Annexure A and pass necessary orders within 30 days from the date of receipt of a copy of this order. Made clear that this court has not expressed any opinion. The entitlement of the petitioner, same, the application would have to be considered as per the applicable law.
Grateful minutes.
ಅಲ್ಲ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ಗೆ ದೇವರಾಜು ಇದ್ದಾರೆ, ಅವ್ರು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಅವರು ಇದ್ದಾರೆ. ನಾನು ಆಕ್ಚುಲಿ ನಾನು ಲಿಸ್ಟ್ ನಾನು ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ದೆ, ಇಲ್ಲ ನಾನು ಹೊಸದು ಕೊಟ್ಟಿದ್ದೆ, ಇಷ್ಟು ದಪ್ಪ ಇದೆ ನಮ್ಗೆ ಅದೇ ಇರ್ಬೇಕು ನೋಡಿ. ಹಾ ನಾನೇ ಕೊಟ್ಟಿದ್ದೆ, ಅದ್ರಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ. ಹೌದು ಅದೇ ನಾನು ಕೊಟ್ಟಿದ್ದೆ.
Recreation Club.
Recreation Club.
23, same order as
Club that.
serial number 6.
24, K. Mahabaleshwara Rao.
Petitioner.
Yes.
The petition sought for order at the hands of Assistant Commissioner. In fact, this petition was filed on 3/2/2026 for over a period of 2 months. No action was taken by the ACI. This is a senior citizen matter, my lord. The interim order has been denied. He is against that order.
ಮತ್ತೆ ಇದು ಅಂತೆ ಸರ್ವೆ ಅಂತೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? And AGA accepts notice for respond number 1, issue notice to respond number 2 written up by 29th September. Respond number 2 is restrained from any manner dealing with alienating, encumbering or creating any charge or changing the character of the subject property till the next date of hearing. Process fee and copies
In
to be
fact, this
furnished.
matter, this can be disposed of, my lord. Illa notice. Interim order, the matter is pending there.
There's a ex parte interim order. Whether we have to confirm it, we'll have to see. Process fee and copies to be furnished by end of day 17th August, failing which the interim order will stand automatically vacated.
25, Rahul S. Reddy.
That's it.
Yes, Mr.
The
Reddy.
second petitioner, your lordship, against is the managing director of the first petitioner. And your lordship against in 20, that authorized share capital of 100 crores. Wherein on 25/3/2015, ED passed a provisional attachment order. Then thereafter, that case is still pending. In the meantime, your lordship can see that R3 and R4
Mandamus.
was appointed as the provisional directors on 9/3/2024. Then without issuing the notice to the MD, your lordship can see on 19/3/26, 25/3/26, 28/5/26, and subsequent dates have passed a resolution stating that they will sell all the shares. And the ED has attached this property, your lordship can see, then the account
The
said.
writ petition maintainable for implementation of the
because-
resolution or
Not
staying the resolution.
My prayer is your lordship, we made a complaint to the registrar of companies.
Your reliefs.
Yes.
Please see your reliefs.
Direction may be given to the registrar of companies to dispose of that complaint as early as possible, because of that he wanted to sell all the shares. Major share is belongs to the petitioner, number 2. Only direction, writ of mandamus.
Only direction, very nice, only.
What happened? ROC has not
Only there
taken
must
care of
be
that.
jurisdiction, Mr. Reddy. This is a dispute between two of your shareholders. How will a mandamus be issued? to
Not,
the
he is
ROC?
not the shareholder. That R3 and R4 are the not shareholders.
If he is not also, it's a dispute between yourself. It's not a issue between any statutory authority or
No,
a state
the
authority.
Lordship can say that even ED was attached to his shares. Then your lordship R3, R4 subsequently was nominated by some other person. And in turn, he passed the resolutions without issuing a notice to the MD. That is one aspect. We made a complaint to the ROC, Registrar of Companies. Take action against him. But your lordship, you can say they manage the ROC register of companies.
Policy cannot take any action on that. You have to file
No,
appropriate proceedings. We can't tell you under what provision. You have to
No,
file
no, no,
appropriate proceedings. This is not matter. This is a private list between you.
Alam, any order passed by the ROC, then I have to approach the NLFCTA.
Shri Aditya Singh is directed to accept notice for respond number 1 and 2. Notice to respond number 3 and 4 is dispensed with the view of the order proposed to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respond number 3 and 4 are dealing with the shares of petition number 1 as regard without any authority as regard which a complaint had been filed with respond number 2. Respond number 2 not having taken any action, the petitioner is before this court seeking for the aforesaid relief. Ex facie, the dispute is between the petitioners and respond number 3 and 4 as regard the shares held in ex facie, the dispute is between petition number 2 and respond number 3 and 4 as regard the shares in petition number 1, which is a private list between parties. In that view of the matter, a mandamus cannot be issued to not act on a resolution passed by the board, allegedly passed by the board, or as regard the legality of the CCDs and equity shares which have been issued, or to the ROC not to accept, process, register, or act upon any statutory forms or filings made on behalf of the first petitioner company in connection with the alleged board meetings and general meetings. If at all, if at all there any dispute between petition number 2 and respond number 3 and 4.
A similar circumstances, your lordship, Andhra, Telangana High Court has passed an order.
It can't be passed.
That's only is.
It cannot be passed. These are your private lists. Don't involve statutory authorities. If at all the petition, if at all the disputes between, if at all there are private disputes between petition number 2 and respond number 3 and 4, it would be for them to agitate. It would be for the petition number 2 to agitate the same before the appropriate authorities. Reserving such liberty, petition stands disposed.
26. 26, Divyatej Hitchin.
Divitesh.
Petitioner, my lord, respondent number 3 husband initiated action against my lord under Senior Citizens Act against the wife, 2 sons and daughter-in-law, my lord. The respondent at the number 1 and 2 authority has passed under liability only on wife, my lord. Even as per the act, my lord, the proceedings against the wife is not maintainable.
Where is the order?
My lord, order at annexure B, my lord, is the order passed by the assistant commissioner, and annexure F is the order passed by the special deputy commissioner. Even wife has prepared the appeal against the assistant commissioner order, my lord. That was not considered. The appeal filed by the husband was considered and passed the order. And more shocking thing is, my lord, the authorities are using police machine. Even they have arrested the petitioner. When the advocate went and objected the same, they released her.
Even one of the advocates trying to misuse the police machinery because they are advocates.
No, my lord. In this case, my lord, there is no.
We are getting all kinds of issues. Advocates are being, unfortunately, advocates are being arrayed as accused. You should tell your.
My lord, I would like to take your lordship to the act itself, my lord. The Maintenance and Welfare of Parents and Senior Citizens Act.
How can Senior Citizen Act be used for maintenance? And AG accepts notice for respond number 1 and 2, issue notice to respond number 3 to 6, returned by 29th September. The operation of the order dated 15/10/25 passed by respondent number 2, insofar as direction to the petitioner to make payment of maintenance to respondent number 3 is concerned, is stayed till the next date of hearing, since the petitioner, wife of respondent number 3, would not qualify as a child under, as a child under
2G, my lord.
2A of the Senior Citizens
Yeah.
Also Act, nor would she qualify as a relative under section 2G of section 2 of so and so Act. Process fee and copies to be furnished by end of day 17th August, failing which the interim order will stand automatically
My
vacated.
lord, one more interim order, my lord, I have sought, my lord, at interim order B, my lord. They have issued the direction to the deputy director to hold my salary, my lord. Kindly take, my lord, annexure G and H, my lord.
G, Mate, you have not asked for any interim order.
I have asked, my lord.
Yes. H, Chelli?
G and H, page number 61, my lord.
61.
61. Annexure G is the direction issued to the deputy director, and H for to police inspector, my lord.
How do they issue these orders?
Based on this order, my lord, police have arrested the petitioner and
Against the wife, my lord. I will.
This will require action to be taken against them.
Yes, my lord.
Firstly, a legal order. On top of that, getting the wife arrested for maintenance.
I will check out the instructions, my lord.
The operation of annexure G and H are also stayed till the next date of hearing. The Principal Secretary Revenue Department, the Additional Chief Secretary and Principal Secretary Revenue Department is requested to look into the matter and the manner in which the orders have been passed. Firstly, by exercise of jurisdiction when none exist under the Act. And secondly, by using the official machinery at the behest of respondent number 3, which could not have been so done. Report to be filed by the next date of hearing.
My lord, sorry to interrupt in the middle of the hearing, my lord. My lord, I was waiting here to make my submissions to appear on behalf of R1 and R2 in serial number 25, my lord. But I was not let in to make my submission. After
As
the
we have
case is
discussed the
over,
matter, madam, we'll say you are accepting notice for R1 and R2.
please.
25, well, Ms.
Great.
Anupama Hegde accepts notice for respondent 1 and 2.
Great, my lord.
27, Harish Bhandarati.
I1 of 26 is allowed.
This is the case, your lordship. Municipal Council Mandya issued the some civil works, your lordship, that's our road and laying of the footpath and some other works, your lordship. Your lordship, you kindly turn to page, your lordship, the estimated cost, your lordship, referred at page annexure D. Your lordship, kindly turn to, your lordship.
Annexure?
Annexure D, your lordship, page 81.
81.
81. Annexure D. This is the cost of the works, your lordship, is measured by the executive engineer, your lordship. In this, your lordship, kindly turn to page 83. This is the work, your lordship, in 83, your lordship, where repairs of manhole, machine hole for different depth, including the removal, so and so. These are all the works, your lordship, for construction of the manholes in the road, your lordship. This is totally number, your lordship, in the various ward numbers, your lordship, amounts to 89 number of manholes, your lordship.
Yes.
The total cost of this manhole, your lordship, according to their cost, your lordship, 7,48,000 rupees. This is the total cost, 7,48,000 rupees, your lordship. Followed with this, your lordship, a tender was issued, your lordship. Tender it annexure F, your lordship. Page 117.
Yes.
Before that, your lordship, the intent that was issued, your lordship, at annexure B, before calling tender, page 29, your lordship, kindly refer to once, your lordship. Your lordship, page 9.
Page 29.
Page 29.
Yes.
Your lordship, There, your lordship, 3.2, your lordship, get it, your lordship. To qualify the award of this contract, each tender in the name should have to be last 5 years, so and so. The achieved, all this A, B, C is not relevant, your lordship. When it should come to the annexure C, your lordship, clause C, executed any 1 year for the continuous period of 12 months, the following minimum quantities of the work. In clause 6, your lordship, kindly refer to. This is total number of 71 manholes to be done. Minimum he has to done in the manhole 71.
Yes.
So total number is there, your lordship. This. Now your lordship, kindly turn to annexure E.
Yes.
There, your lordship, first page alle. ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಗುತ್ತಿಗೆದಾರರ ಸಂಘ 29/10/24 ಮನವಿಯಲ್ಲಿ KW through KW4 ಈ ಪ್ರೊಕ್ಯೂರ್ಮೆಂಟ್ ಮುಖಾಂತರ ಟೆಂಡರ್ ಕರೆಯುವ ವೇಳೆಯಲ್ಲಿ ಕೆಲವು ನಿಬಂಧನೆಗಳನ್ನು ಅವೈಜ್ಞಾನಿಕವಾಗಿ ಸೇರಿಸಿದ್ದು ಕೆಲವೊಂದು ಗುತ್ತಿಗೆದಾರರು ಮಾತ್ರ ಅನುಕೂಲವಾಗುತ್ತಿದೆ ಎಂದು ತಿಳಿಸುತ್ತಾ ಇದನ್ನು ಸರಿಪಡಿಸಲು ಸರ್ಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇತ್ತೀಚಿನ ದಿನಗಳಲ್ಲಿ ಸರ್ಕಾರದ ಮಟ್ಟದಲ್ಲಿ ಬಹಳಷ್ಟು ಟೆಂಡರ್ಗಳು ಅದರಲ್ಲಿ ತಾಂತ್ರಿಕ ಬಿಡ್ಡಿನಲ್ಲಿ ಅನರ್ಹಗೊಳಿಸುವ ಬಗ್ಗೆಯೂ ಅಪೀಲ್ಗಳು ಬಂದಿರುತ್ತವೆ. ಆರ್ಥಿಕ ಇಲಾಖೆ ಆದೇಶ ಸಂಖ್ಯೆ ಕಾಮಗಾರಿ ಟೆಂಡರ್ ಕರೆಯಲು ಉಪಯೋಗಿಸುತ್ತಿರುವ KW3, KW4 ನಿಬಂಧನೆಯನ್ನು ಅಳವಡಿಸುವಾಗ ಕ್ಲಾಸ್ 3(2) ಸಬ್ ಕ್ಲಾಸ್ ಸಿ ಮತ್ತು 3 ಕ್ಲಾಸ್ 3 ನಲ್ಲಿ ವಿವಿಧ ಟೆಂಡರ್ ಕರೆಯುವ ಪ್ರಾಧಿಕಾರಗಳು ವಿವಿಧ ವೈಜ್ಞಾನಿಕ ಷರತ್ತುಗಳನ್ನು ವಿಧಿಸುವ ಸರ್ಕಾರದ ಗಮನಕ್ಕೆ ಗಮನಿಸಿದೆ. Based on this, your lordship, the clause 3, your lordship, next page, your lordship. These are all the how the 80% has to be, your lordship has to previous work ಮಾಡಿರ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ಕೆಳಗೆ your lordship ಮೇಲೆ ತಿಳಿಸಿದ, your lordship got it. Below in that yes ಐಟಂಗಳ ಜೊತೆಗೆ ಅತಿ ಮುಖ್ಯವಾದ ಯಾವುದಾದರೂ ತಾಂತ್ರಿಕವಾದ ಐಟಂನಲ್ಲಿ your lordship got it. ಅನುಭವ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಹೊಂದಿರಬೇಕಾದಲ್ಲಿ ಇದರ ಮೌಲ್ಯವು ಅಂದಾಜು ಮೊತ್ತದ 15% ಹೆಚ್ಚು ಇದ್ದಂತ ಐಟಂಗಳನ್ನು ಅಂದ್ರೆ ಟೋಟಲ್ ಕಾಸ್ಟ್ ಆಫ್ ದಿ ವರ್ಕ್ 15% ಎಬವ್ ಇದ್ರೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಟೆಕ್ನಿಕ್.
ಇದು 4 ಐಟಮ್ಸ್ ಇರೋದು ಡಾಂಬಾರ್ ರಸ್ತೆ, ಕಾಂಕ್ರೀಟ್ ರಸ್ತೆ, ಕಟ್ಟಡ ಕಾಮಗಾರಿ, ಸೇತುವೆ. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ತೀರಾ? ಇದ್ರಲ್ಲಿ ಮ್ಯಾನುವಲ್ ಎದ್ರಲ್ಲಿ ಬರುತ್ತೆ?
ಯಾವ ಸರ್
ಮ್ಯಾನುವಲ್ ಹೆಂಗ್ ಬರುತ್ತೆ ಇದ್ರಲ್ಲಿ?
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು ಇಲ್ಲಿ ಇವರು ಕೆಲ ಕಡೆ ಹೇಳ್ತಾ ಇರೋದು 15 ಹೆಚ್ಚು ಇದ್ದಂತ ಐಟಮ್ 3.6 ಸೂಕ್ತ ಅಂದ್ರೆ ಎನಿ ಐಟಮ್ ಓವರ್ ಅಂಡ್ ಅಬೌವ್ ದಿಸ್ 15% ಗೆ ಮೇಲೆ
letter which had been sent not as regard this tender. ಹೇಳಿ, what is your submission?
ಮೇಲೆ ತಿಳಿಸಿದ ಐಟಮ್ ಜೊತೆಗೆ ಮುಖ್ಯವಾದ ಯಾವುದಾದ್ರು ತಾಂತ್ರಿಕವಾದ ಐಟಮ್ ನಲ್ಲಿ ಅನುಭವ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಹೊಂದಿರಬೇಕಾದಲ್ಲಿ ಇದರ ಮೌಲ್ಯವು ಅಂದಾಜು ಮೊತ್ತದ 10% ಹೆಚ್ಚು ಇದ್ದಂತ ಐಟಮ್ಗಳನ್ನು 3.C ನಲ್ಲಿ ಸೂಕ್ತ ಪ್ರಾಧಿಕಾರದೊಂದಿಗೆ ಅನುಮತಿಯೊಂದಿಗೆ ಅಳವಡಿಸಿಕೊಳ್ಳುವುದು. Now my submission is only this much, your lordship. According to the intent, what is referred, your lordship, 71 manholes, your lordship. In the previous term, your lordship, I have conducted the, your lordship, kindly turn to page 122, 123. The manholes, 27 number of manholes I conducted in the previous years, your lordship.
Yes.
Now my submission, your lordship, this 15% was taken into, which 15% was taken into as a technical bid when it is considered, your lordship. This amount of rupees 3.5 crores rupees working, this 15% of manhole will does not comes under the 15 to that. It is comes lesser than that.
Sorry, what is your submission?
That your lordship, this
3.5 crores ಯಾವ್ದು ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಯಾವುದು?
What is 3.5 crores?
ಅಲ್ಲ, total value of the tender was 3.45 crores.
4.48, 430 lakhs.
430 lakhs. ಈ ಟೆಂಡರ್ ನಲ್ಲಿ ಮ್ಯಾನ್ ಹೋಲ್ ಬರೋದೇ 7,48,000.
ಹೌದು.
ಈ 7,48,000 ಟೋಟಲ್ ಟೆಂಡರ್ ನ 15% ಆಗೋದಿಲ್ಲ. ಮ್ಯಾನ್ ಹೋಲ್ ವರ್ಕ್, ದಟ್ ಇಸ್ ಮ್ಯಾನ್ ಹೋಲ್ ವರ್ಕ್ ಇಸ್ ಎ ಟೆಕ್ನಿಕಲ್ ವರ್ಕ್. ಸೊ when it 15% over and above 15% ಬಂದ್ರೆ ಮಾತ್ರ it is placed before the higher authority and they are not eligible for participation. ಈ 7,48,000 ಬರೋದೇ 2% ಬರ್ತದೆ ಟೋಟಲ್ ವ್ಯಾಲ್ಯೂದು.
that is the criteria that they have fixed. You can go on appeal on this.
I have filed the appeal now.
ಏನಾಯ್ತು?
I filed the appeal. Appeal is not considered. Now they have rejected my tender, your lordship, only on the technical issues now.
That you did not qualify for it.
Only on that,
What
that ground.
happened, what happened in the appeal?
Appeal is not yet heard, your lordship. Now, your lordship, annexure B, your lordship, kindly turn to. Annexure B nalli, that your lordship, last one, page 23 nalli. All documents are uploaded.
Page number 23.
Page number 23. My rejection of tender, technical bid. All documents are uploaded, but new machine holes rising quantity is nil. Hence, the bidder is recommended for rejection. So, adu nan contention ಏನಂತಂದ್ರೆ ಆ 15% ಒಳಗಡೆ ಅದು ಬರೋದೇ below the 2.5 ಬರ್ತದೆ total value ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
You participated in bill, you are coming after your rejection.
But your lordship, the circulars are issued periodically, your lordship, for this purpose only.
That
Because that, your lordship kindly turn to, even in the tender notifications.
One of the major portion of that work is manuals to be done, and to be done in a scientific, in that machine manuals. 89 is the requirement. They have asked for 71 to be done by
71.
you.
I have previous year I have
You
done
have uploaded
27.
nil and you have done 27, which is
Yes.
way less.
So this nature of conditions are imposed, your lordship, only to see that particular tenderer has to be accommodated, your lordship. This is my submission, your lordship. Because annexure C, your lordship.
You are on appeal, so it will be subject to the appeal.
Till then, your lordship, not to.
We can't do that. You can ask that in the appeal.
They have not,
AGA
within 30
for-
days, they are supposed to.
That will direct them to dispose. And AGA for respond number 1 and 2. CMC Mandya,
MS Devraj.
MS Devraj for 3, 2, 6. Notice to respond number 7 and 8 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The sole contention of the petitioner is that his bid for the tender issued in terms of Annexure D could not have been rejected on the ground that he did not have sufficient experience in construction of machine holes for different depths. The submission of Shri Harish Bhandari, learned counsel for the petitioner, is that in terms of tender, 89 such machine holes being required, the minimum qualification, minimum technical qualification prescribed under clause 3.2C, bracket 6, was 71. And in this regard, he relies upon a circular dated 17/11/2014 at Annexure E, to submit and submits that the minimum qualifications are being fixed in an arbitrary manner so as to favor certain tenderers. A perusal of Annexure E indicates that the specifications, the minimum qualification requirements have been specified in respect of a tar road, cement road, construction of building and construction of a bridge, where
ಜೊತೆಗೆ ಅಂತ ಇದೆ ಅದು ಐಟಮ್ಗಳ ಜೊತೆಗೆ ancillary works for that. Sorry, your lordship.
wherein the technical qualification has been recommended to be 80% of the total estimated quantity. Insofar, his submission, by relying on the further portion of the said circular, is that in respect of ancillary works, it could only be a maximum of 15% of the estimated work which could be taken into consideration for fixing the minimum technical qualification. And on that ground, he submits that quantity of 71 machine holes could not have been fixed in respect of the tender which requires 89 machine holes to be constructed. The the submission of learned counsel for the petitioner. You want a finding on this when your appeal is considered?
Findings were.
ಮತ್ತೆ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ we'll have to deal with it.
3-2C ಬಗ್ಗೆ ಒಂದು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕೆ ಮಾತ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ ಒಂದು.
ನಾವು ಅದನ್ನ ಡೀಲ್ ಮಾಡೋದು ನಿಮ್ಮ ಅಪೀಲ್ ಹೋಯ್ತು.
ಅಲ್ಲ, only your lordship say your lordship 3-2C to be considered in the process. ಯಾಕಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಅವರೇ ಹೇಳ್ತಾರೆ ಅದರಲ್ಲಿ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ.
If you make an submission, we have to deal with it. But this we deal with it, your appeal will go.
Lordship say the appeal to be disposed in terms of the
petitioner has already filed an appeal challenging the said tender which is pending. Learned counsel for the petitioner submits that instead of considering the merits of the present petition, if a direction could be issued for the appellate authority to dispose of the appeal as expeditious as possible, the petitioner's grievance would be for now addressed. In that view of the matter, this court passes the following order. Respondent number, who is the appellate authority?
appellate authority, your lordship, that is municipal director administration, lordship. First now.
The first respondent. He is directed to dispose of the appeal which has been filed on, when did you file it?
That appeal has been filed, your lordship.
Date ello ilvalla.
Annexure J, your lordship, that is on page 177.
When did you file it?
Lordship, that is on
6/8.
28th July, 28th July.
Inna one thing ಆಗಿಲ್ಲ. At appeal at Annexure J as expeditious as possible within the time frame fixed under KTTP Act.
28, Harish Kumar MS.
The petitioner was entered the sale agreement manner and produced before respondent number 2, before the registrar Anekal manner. Then manner it has been withdrawn manner, kindly comes the page number 27 manner.
27.
Yes, ma'am. Next is C, my lord. Absolute sale deed, my lord. The sale deed has been, my lord, in 32. Which was, my lord, the ಕಕ್ಷಿದಾರರ ಕೋರಿಕೆ ಮೇರೆಗೆ ಕರ್ನಾಟಕ ನೋಂದಣಿ ನಿಯಮ 1965 ನಿಯಮ 193 ಅಂತೆ ಕಕ್ಷಿದಾರರಿಗೆ ದಸ್ತಾವೇಜು ವಾಪಸ್ಸು ಮಾಡಲಾಗಿದೆ. ಇದಕ್ಕೆ ತಗಲುವ ಫೀ ರೂ 200 ಚಲನ್ ಸೋ ಅಂಡ್ ಸೋ ದಂತೆ ವಸೂಲಿ ಮಾಡಲಾಗಿದೆ. Then my lord, the 13 lakhs is stamp duty and 2,30,000, my lord, I request to my lord, till today not paid, my lord. Hence I given the representation, my lord, kindly come to the page number 43, my lord.
Lord, as in the representation, they are seeking refund of stamp duty along with an interest of 12%, which is not permissible.
Interest will not be there, but
Not even interest. Along with that, my lord, we'll have to deduct 20% of the stamp duty, 50% of the registration fee, because it is to be termed as an unused stamp.
what is that provision? Why did you withdraw after submitting?
Could not complete some vendors. Similar
provision.
This honorable coordinate bench is, my lord.
Which is 47.
Paragraph 11, my lord.
The Lordship may kindly see section 47 of the Stamp Act.
There's a categorical finding, para 12 and 11, 10 and 11. Transaction does not go through, refund.
So there they say this is the delay, my lord.
ಅದಕ್ಕೆ ಡಿಲೇ ಅಂತಾನೆ ನೋಡಿದ್ದು, but if you look at 10 and 11, that's why we read through the entire. So irrespective of, even if there's a delay, you have to refund, and mail you have to refund.
No, we will refund, my lord. Refund of the stamp duty will be permitted. Here the case is, my lord, he asked, what I am telling, my lord, it's 47, your lordship may kindly see. Section 47 of the act.
In the light of the act and the rules and government order dated 21/2/2009. After permissible deductions.
After deductions.
So whatever deductions you need to make, you have to make and return it. He's also relying on para 11.
11, my lord. That's what, my lord. That is what I was telling you. Even 47, my lord. 47C, my lord. B, my lord. A stamp on document which is written out wholly or in part, which is not signed. Any of the parties, they are entitled for a refund because it's a spoiled stamp, to be considered as a spoiled stamp. So in this case, my lord, the representation is to give interest at 12%.
As per applicable law only, they'll ask everything.
Yes.
They asked interest also.
In the memo minute.
Petitioner, then AGA accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following leaves. The petitioner was intending to purchase agricultural land bearing survey number 57/P2 situated at Singena Agrara village, Sarjapura Obli, Anekal Taluk, Bengaluru, and enter into a sale deed with the owners thereof. The petitioner purchased the requisite demand drafts in respect to stamp duty, registration fee, and other charges, and deposited same with the respondent registrar, sub-registrar. However, for certain reasons beyond the control of the petitioner, the sale transaction could not be completed. And on 16/6/2021, the petitioner formally, the presenting parties formally withdrew the said document from registration and requested only an amount of rupees 200 having been refunded. The petitioner submitted a representation on 21/6/2021 seeking for the refund along with 12% interest. Sri Harish Kumar, learned counsel for the petitioner, relies upon the decisions of the coordinate bench of this court in WP number 103500 of 2026, more particularly para 11. Relying upon the said judgment of the coordinate bench, his submission is that even if there was a delay, there is a requirement for refunding the stamp duty in terms of the provisions contained 21/2/2009. His submission is that the respondent ought to have acted in terms thereof and refunded the appropriate amount.
Even in
Without-
the judgment, they said, my lord. Even in the judgment, they have said the rule corresponding contemplates refund of one half of the registration. So we'll deduct that and we'll.
You have not done that also. When Bantama? Acted in terms of the applicable, the Indian Registration Act would have to have acted in terms of the above and refunded the appropriate amount, which has not been done. Learned AGA also places reliance on the Act, rules, and the government order to contend that appropriate deduction would be made and payments would have to be made, and thereafter payments would be made to the petitioner. the said submission now made after nearly 5 years does not inspire any confidence.
My lord, if I may.
You should have
submit.
refunded it earlier.
He has made an application to the wrong authority. He has made it to the revenue secretary. Principal Secretary, Revenue Department, who is not the authority under 52A, my lord.
You should forward it to the concerned authority.
Yes, my lord. Yeah.
How many people, citizens know who is the appropriate authority?
The Act 52A is very clear, my lord. It is the deputy commissioner.
Everybody
Yeah,
is
my lord.
not,
Let him make, let
they are not even literate. Where is the legal literacy?
Now, my lord. Let them make an
The-
application to the deputy commissioner.
Does
of
not
staff.
inspire confidence. The further submission of learned AGA is that the application for refund had been made to the Principal Secretary Revenue Department on 21/6/21, who is not the appropriate authority, and as such, action could not be taken. Irrespective of the said submission of learned AGA, this court is unable to agree with the submission of learned AGA in as much as citizens of the country cannot be presumed to know who is the appropriate authority to make the application to. Legal literacy is still required to be achieved. When an application is made to a particular authority, if that authority is not the concerned authority, the authority ought to have guided the petitioner to approach the appropriate authority and or transferred the said proceedings to the appropriate
In
authority.
that COVID period, they only sent me at that.
The application was incidentally filed during the COVID pandemic. It was more so required for the authorities concerned to have forwarded the application to the concerned and appropriate authority by guiding the petitioner to do so. The same not having been done, it cannot now lie for the respondents to contend that the application had been filed before the wrong authority. With the changing times, it is required for the state administrative mechanism and machinery to evolve in a manner to take care of the interest of the citizens and not take a hyper-technical approach as that is sought to be taken in the present matter. The application of the petitioner pending from 21/6/2021, though the learned AGA is right in contending that certain deduction could be made, the fact that the said application had not been processed would require this court to award interest to the petitioners. In that view of the matter, this court passes the following order. Writ petition is allowed. A mandamus is issued directing the, which respondent now?
My lord, it's the
District
commissioner.
registrar. Amale, that authority was not a party to the order ಅಂತ ಹೇಳ್ಬೋದು.
It has to be done by the collector. 52A says collector.
Collector and district registrar.
District,
Deputy
district registrar,
The concerned
deputy commissioner,
authority
concerned officer.
to process the said application of the
Let them
petitioner.
make a fresh application, my lord. After,
Then our whole reasoning will go. You forward it to that concerned authority to process the application of the petitioner dated 21/6/21 and refund the amounts as held by the coordinate bench of this court in WP number in Gopal Rao's case within a period of 45 days from the date of receipt of a copy of this order. The first respondent is direct forward the application of the petitioner at Annexure D to the appropriate authority within 1 week from the date of receipt of a copy of this order.
no interest, my lord. No interest.
ಇಂಟ್ರೆಸ್ಟ್ ಹೇಳಿಲ್ವಲ್ಲ
ಅಲ್ಲಲ್ಲ, ಬೇಡ ಅಂತ.
ನೀವೆಲ್ಲ ಒಂದ್ಸತಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಇಲ್ಲ,
So that next time it will be done properly. This is not a big amount also. While processing the application of the petitioner, the respondent is also directed to make payment of interest at the rate of 6% per annum calculated from the date on which the application has been filed to the date of payment.
29, A. Velam, Shantiya.
Appearing for petitioner, my lord. My lord, I pray for an adjournment due to personal inconvenience of the senior, my lord. Any day next week, my lord.
It's not come today.
But this matter, my lord, is a wrong classification, my lord. This is the absorption.
Consider it.
We can consider, my lord, and also the locus of the petitioner, my lord. The petitioner is an authority, is a Sangha.
Is an association of those.
Association of, how can they come before the court seeking
They need to
absorption?
pay court fee of 100 people. Come like that. Consider it. And AGA accepts, is directed to accept notice for respondent number 1, 2, 3. Karnataka Examination Authority, KEA, NK Ramesh.
NK Ramesh.
NK Ramesh for respondent number 4. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner, the petitioner's claim to be, the petitioner claims to be an association of licensed surveyors across the state of Karnataka. The petitioner association had submitted a representation on 3/8/26 to, among others, to the first respondent as also the third respondent on 3/8/26 Aitala. Despite the said representation submitted on the respondents have not taken any action nor even provided an opportunity of the petitioner association to present their grievances before the authorities. Whenever any representation is submitted to an authority, it is required for the authority to consider the same and pass necessary orders, either accepting or rejecting the same, in either case accompanied by reasons. Neither of it having been done in the present matter, and when the petitioner represents an aggrieved class of people, namely the licensed surveyors, it was but required for respondent number 1 and 2 to pass orders within a reasonable period of time. Hence, this court passes the following order. Writ petitions allowed. Respondent number 1 and 2 are directed to consider the respondent number 1 to 3 are directed to consider the representation submitted by the petitioner on 3/8/26 at Annexure B and pass necessary orders within a period of 30 days from the date of receipt of a copy of this order. It is made clear that this court has not expressed any opinion on the entitlement of the petitioners and/or entitlement of the petitioner and/or its members. It is for the respondents to pass necessary orders in accordance with law. Allowed, madam.
Thank you. Much
30,
obliged.
Shailesh S. Katari.
But I appear for the petitioner.
Yes, Sailesh.
Lord, in this case, this is with reference to section 10A of the Banking Regulation Act. But an
10A or
indigenous
108?
way has been found by the board of the seventh respondent bank to first resign and co-opt, that too within a short period of 1 year. An indigenous way has been found, ingenious way.
This is 10A or 108?
You know?
108 alva, ಇದು 10A na? Banking
sorry,
Regulation Act ಕೊಡಿ.
10, correct.
Banking Regulation Act. Banking Regulation.
Central.
10A 2A1.
Oh, 25th May, Annexure C, man. I have- Page 30.
You're not challenged the.
No, no, I'm not challenging, my lord. In fact, I'm supporting this provision. An ingenious way has been found by some of the directors by first resigning within a period of 1 year after the election, making their family members as the board of directors by co-opting them. That your lordship finds at Annexure A. To overcome the provision, it's say Annexure C, they have come up with this new way of resigning and co-opting.
Ms. Nayantara BG is directed to accept notice for respondent number 1 to 3.
My lord, I have been allotted.
You have been allotted.
Please.
For Union of India.
For 1 to 3.
So also for respondent number 1 to 3. Who is Manik BT for Reserve Bank of India, respondent number 4. And AGA for 5, 6, 7. Issue notice to respondent number 8 to 27. returnable by so and so, ಅದು ಬೆಳಗ್ಗೆ ಇತ್ತಲ್ಲ ಅದು 108 10/2A, same date, connect with so and
It is
so.
on 25th, I am told, my lord. That's
Connect
what I-
with so and so.
Anyway, it may be connected.
Because even in that, the service of summons is not complete.
Please, I can understand. In this interim order may be granted, my lord.
Not now. The act is there, we'll have to determine that. This issue also will be considered along.
Please.
31, an appeal.
Only one case, my lord, initiated against me at the instance of State Bank of Mysore. It was investigated by CBI, my lord, in which there is a final order of discharge. And no other criminal cases against me. Based upon this very case, my lord, the order of discharge, my lord, I have produced at, my lord, annexure A, my lord, which is at page number 59. I'm sorry, my lord, at annexure E, page number 59. The operative portion is on page number 84. Except this, my lord, there is no case. Now I am acquitted of this case.
No appeal has been filed.
No appeal has been filed. But, my lord, ED now, my lord, based upon this, initiates, my lord, ECIR proceedings and summons me. My lord, Vijay Madan Lal and Pavana Debut.
Well, that's covered by the judgment of the Honorable Supreme Court that discharge for lack of sanction cannot vitiate the PMLA
It's
proceeding.
not for lack of sanction.
It is want of sanction.
This is
My lords,
discharge
make
for what reason?
sanction, want of sanction at
Where is
page
the reason?
83.
That's
There are
not.
29. However, the learned public prosecutor by
No,
reference-
let's first see the discharge order.
Yes, my lords, it's on 29 June. It is still within the appeal period
29 June,
of this year, 29 June 2025, 26.
but what was the reason for discharge?
Sanction, lack of sanction.
No, not sanction.
Where does it say that, madam?
29, para 29.
Para 29.
Please, my lords, at page 82.
The discharge order is that the CBI could not have investigated the case when there is no public servant. But I am not a public servant. And the my lord, court goes on the jurisdiction. CBI could investigate the case under, my lord, a non-referred case only if it is against a public servant. But in this case, there was no
Of sanction here.
Please, my lords.
Where the question of sanction?
There is no question of he was discharged because the FIR says that there are certain unknown public servants. Now the complaint has not been produced. This order says that discharged because it was not in accordance with law because they have not taken sanction for those officials who are named. It is not the case that the crime has not happened. My lords, that is what the Honorable Supreme Court have said in the recent judgment.
This is lack of consent by the state of Karnataka for CBI investigation. That is
lack
the
of
reason.
consent and also, my lord, lack of jurisdiction. My lord, I am not a public servant. There is no public servant involved. In spite of that, CBI investigated the matter. Place 35, my lord, is the charge sheet. Initially, my lord, the complaint said there could be some public servants.
Yes, but now still it's in the appeal period.
It is
It can't come so soon.
My lord, our Honorable High Court, my lord, if there is an appeal filed, my lord, they can revive also. But, my lord, the law laid down in, my lord, Vijay Madan Lal and Pavana Debut, my lord, with both the judgments may just pass on only.
What is this judgment that you wanted to?
My lords, may kindly.
It is, my lord,
Karnataka look at. Sir, you got the judgment. Sir, my lords, may
My
kindly
lord,
come
it is
to
on the
para
ground of
3.
sanction. If, my lord, the sanction
If
was not
both
a
of you
dispute-
are,
I'm sorry.
we are asking madam a question, you respond.
I'm sorry.
You will become madam.
I'm sorry. I'm sorry. My lord, only one paragraph, my lord, in
Madam.
Vijay Madan Lal.
We'll come to you.
Para-
What is this judgment that you
My
want?
lords, this is a recent judgment when PMLA proceedings were quashed because sanction was not obtained. My lords, may kindly peruse para 3. Why the impugned judgment dated the High Court had discharged the sole respondent in SLP for the predicate offence punishable under section 13(1) of Prevention of Corruption Act. Consequently, the High Court had paused the proceeding against the respondent in SLP initiated under section 3 and 4 of the prevention of money laundering, agree the appellant are before us. We have perused the impugned judgment with respect to predicate offence under PC Act. The High Court has discharged the respondent while going into the issue of validity of sanction, which is specifically prohibited under 19(3) of PC Act. The aforesaid decision of the High Court is obviously contrary to the law laid down by this court in so and so, so and so. In such view of the matter, there is no need to pass any lengthy order except to set aside the impugned judgment passed by the High Court for the predicate offence. In view of the aforesaid quashment of the proceedings under the PMLA also stand set aside. While doing so, we have all the issue, including the question of sanction, left open to be decided at the time of trial. Taking note of the fact that the respondent are senior citizens, so and so, so and so. The question of whether PLO would be maintainable in case of whether predicate offence under Act is quashed or set aside left open. The appeals are allowed. Now, my lords, a judgment of Pavana Dibur has been relied upon.
So this is, now let him make a submission, then we'll come back. So this, because they discharge, yes.
Yes, your lordships may kindly have, my lord, Vijay Madanlal, my lord, only one paragraph. But I have flagged, my lord, that particular portion. It's a longish judgment. Paragraph, my lord, 382.8. The offence under section 3 of 2002 Act is dependent on illegal gain of property as a result of criminal activity relating to a scheduled offence. It is concerning the process of activity connected with such property which constitute the offence of money laundering. The authorities under 2002 Act cannot prosecute any person on notional basis or an assumption that a scheduled offence has been committed unless it is so registered with the jurisdictional police and pending inquiry or trial, including by way of criminal complaint before a competent forum. That this is important. If the person is finally discharged or acquitted of the scheduled offence or criminal case against him is quashed by a court of competent jurisdiction, there can be no offence of money laundering against him or anyone claiming such property being the property linked to the state scheduled offence. My lord, this is one paragraph which my lord holds the field. And my lord, relying on this, my lord, the other latest authoritative pronouncement is Pavana Dibur. My lord, in this paragraph 18, my lord, paragraph 18, my lord, concludes. Pavana Dibur also, my lord, places reliance on, my lord, Vijay Madan Lal Chaudhary, extracts it, and 18 is, my lord, the conclusion. Paragraph 18. In a given case, if the prosecution for the scheduled offence ends in the acquittal of all the accused or discharge of all the accused or proceedings of the scheduled offence are quashed in its entirety, the scheduled offence will not exist and therefore no one can be prosecuted for the offence punishable under 3 of pre-MLA as there will not be proceeds of crime. Rightly or wrongly, whatever the blood ground, sanction or whatsoever it is. Lord, as of today, there is an order of discharge, my lord, that my lord reads to my favor. Now, my lord, if the appeal has to be filed, that has to be filed by the CBI. My lord, EDI cannot prosecute that appeal because, my lord,
they won't have any locus to do that.
And there is no PC Act offence at all here. The discharge order, my lord, proceeded on the ground that there was no jurisdiction for the CBI to investigate this matter. And my lord, referring to our Honorable High Court's judgment, my lord, such that order of discharge, my lord, was passed.
And there it went into the validity of the sanction, which is prohibited in 19(3). Here, that is not the question. Here it has been quashed. It's not sanction. It is that complaint itself could not be registered. Is what the finding is. Not sanction. Want of permission. That is the permission by the state of Karnataka for CBI to investigate. So CBI has no jurisdiction within the state of Karnataka now because the consent has been withdrawn. On a hypothetical basis, we can't do that, madam. Now it's been quashed. Now, if CBI files a, who are you to question that? You are the next prosecuting agency. On the basis of the earlier prosecuting, if CBI were to accept this judgment, who are you? That's all. Correct. But who are you to argue this now? CBI, we understand CBI taking that. Now, if CBI wants to file an appeal against this, let them file an appeal. If they succeed, then you come back. Until then, you look at other cases. It is quashed. So if it is revived, not necessary. Don't you do what is required to be done. Don't be doing everything. Not necessary. Petitioner is before this court seeking for the following reliefs. Okay. It is Lange ಹೊಡಿತಲ್ಲಿ. Sharon. Petitioner is before this court seeking for the following reliefs. Proceedings had been initiated against the petitioner by the respondent arising out of a charge sheet filed by the Central Bureau of Investigation (CBI) in CC number 29835 of 2022, where the petitioner was arraigned as accused number 3 for offences under section 420, 468 and 471 of the IPC. In the said proceedings, an application under section 239 of the Code of Criminal Procedure having been filed for discharge, the 17th ACMM Special Court for CBI cases Bengaluru rejected the said application on 1/9/2025. A criminal revision petition was filed. A criminal revision petition in number 497 of 25 was filed before the 46th Additional City Civil and Session Judge and Special Judge for CBI cases Bengaluru, which came to be allowed on 29/6/26, setting aside the order dated 1/9/25 and discharging the petitioner on the ground that there was no general consent by the state of Karnataka for the CBI to investigate in the state of Karnataka, and as such the registration of the complaint by FIR by the CBI was not maintainable. It is on that basis that the petitioner is before this court seeking for the aforesaid relief. The MS Shamsundar and senior counsel would submit that once there is a discharge of the petitioner in the offence, the respondent would not have any jurisdiction to continue with the proceedings pending before it, inasmuch as the earlier proceedings as would have to be held to have been never commenced at all. In this regard, he relies upon the decision of the Honorable Apex Court in 2013, 12 SCC 1, more particularly para 382.8, thereof which is reproduced hereunder for easy reference. By relying on the aforesaid paragraph of Vijay Madanlal Chowdhury, the submission of Shri MS Shamsundar is that the offence under section 3 of the Prevention of Money Laundering Act 2002, PMLA, is dependent on illegal gain of property as a result of criminal activity relating to a schedule of offence. The authorities under the PMLA cannot prosecute any persons on a notional basis or on the assumption that a scheduled offence has been committed unless it is so registered. Secondly, if so registered, if the person is finally discharged or acquitted of the scheduled offence or the criminal case is quashed by the court of competent jurisdiction, there can be no offence of money laundering against him or anyone claiming such property, being the property linked to or stated linked to the stated scheduled offence through him. His submission is that now that a discharge application has been allowed, the same would come within the ambit of para 382.8 of Vijay Madanlal Chaudhary, requiring the proceedings before the authorities under section 3 of the PMLA to be quashed. He also relies upon the decision of the Honorable Apex Court in 2023-15 SEC 91, more particularly para 18 thereof, which is reproduced hereunder for easy reference. By relying on the opposite paragraph of Pavana Dibur, his submission is that the Honorable Apex Court has held that if the prosecution for the scheduled offence ends in the acquittal of all the accused or discharge of all the accused, or the proceeding of the scheduled offence are quashed in its entirety, the scheduled offence will not exist and therefore no one can be prosecuted for the offences punishable under section 3 of the PMLA Act, since there will be no proceeds of crime. His submission is that in terms of the categorical finding of the Honorable Apex Court, in categorical finding of a full bench in Vijay Madanlal Chaudhary and the division bench in two-judge bench in Pavana Dibur, it is clear that if a proceedings were to be initiated against a person for any scheduled offence where such person is discharged, acquitted or discharged, the proceedings under the PMLA Act cannot continue. And on that ground, he submits that the summons which have been issued by the respondent and the proceedings taken against the petitioner under section 3 of the PMLA Act would have to be quashed. Ms. Annapurna Bardalai, learned counsel for respondent, relies upon the decision of the Honorable Apex Court in SLP criminal number 11870 of 2023, dated 16 September 2025, more particularly para 3 and 4 thereof, which are reproduced hereunder for easy reference. By relying on Lakshman Rao Peshwe, her submission is that the Honorable Supreme Court recently considered the aspect of discharge under the PC Act and held that the discharge made on the ground of there being no sanction would not be a ground for quashing proceedings under section 3 of the PMLA Act. On that ground, she submits that even though the petitioner has been discharged in the criminal proceedings initiated against the petitioner, the proceedings under section 3 would continue since the said discharge is on a technical ground and not on merits of the matter. Heard Shri M.S. Shamsundar, learned counsel for the petition, senior counsel for the petitioner, Ms. Annapurna Bardalai, learned counsel for respondent, perused papers. There is no particular question of law which arises in the present matter. It's only a question of fact as regards which the law has been applied in Vijay Madanlal Chaudhary and Pavana Dibur, vis-a-vis the facts in which the Honorable Apex Court has decided, Lakshman Rao Peshwe. The judgments in the Honorable Supreme Court in Vijay Madanlal Chaudhary and Pavana Dibur are categorical in that if there is an acquittal or a discharge by an accused in the predicate offence, no further proceedings can be taken up under the PMLA. The submission in this regard by learned counsel for respondent is all the accused have to be discharged for the principles in Pavana Dibur to be applicable. In Lakshman Rao Peshwe, the Honorable Apex Court considered that the discharge of the accused in the predicate offense was by considering the validity of the sanction, which could not have been so considered in view of section 19(3) bracket A of the PC Act. Thus, it is on account of the High Court having gone into the aspect of this sanction that the Honorable Apex Court came to a conclusion that the discharge in the predicate offense was not valid and had set it aside. In the present case, the matter is not relating to sanction, but relates to the very jurisdiction of the CBI in registering a complaint and investigating the matter. The revision court having categorically held that there being no power with the CBI to register any FIR and or investigate within the state of Karnataka without the special consent, without the consent of the state of Karnataka, the entire proceedings were ill-founded. That aspect, this aspect goes to the root of the matter and forms the jurisdictional foundation for the exercise of powers by the CBI. The revision court having categorically held that CBI did not have the jurisdiction, the entire proceedings have been quashed, which satisfy the requirement of para 18 of the judgment of the Honorable Apex Court in Pavana Dibur. The Enforcement Directorate is the second prosecuting agency after the prosecution by the first prosecuting agency, namely the CBI. Insofar as the predicate offense, quashed by the CBI, by the revision court, insofar as the first prosecution initiated by CBI quashed by the revision court, it is only the CBI who would have the locus to challenge the said order. The Enforcement Directorate would get jurisdiction only when the prosecution in a predicate offense is pending. Now that the prosecution of the predicate offense has been quashed, now that the petitioner has been discharged in the predicate offense and there are no proceedings which are pending against the petitioner, by holding that the CBI has no jurisdiction to register the FIR or investigate into the matter, the Enforcement Directorate cannot have an independent, cannot stand independent of the CBI. Hence, this court passes the following order. Writ petitions allowed. The summons dated 3/8/26 in so and so at Annexure A and any proceedings taken in pursuance thereof by the respondent are quashed. Liberty is, however, reserved to the respondent to reinitiate the action in the event of CBI filing an appeal and succeeding in those proceedings.
Greatly obliged.
Amog Hebbar.
Parole matter, my lord.
General parole.
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 Learned AGF for the respondent released on 19th.
33. Muralidhar HM.
Yes, Mr. Muralidhar.
For the petitioner, I sought for a writ of mandamus to the respondent police to extend police help to protect my property, my lords.
Have you filed any suit and got any order?
Yes, my lords.
Where is that
An
order?
injunction order is there.
Police help order is there?
Pardon, my lords?
Police help order has been there?
Police help order is not there, but an injunction order is there, my lords.
Where is that?
My lords would get that in page 28.
Page?
In page 28. Annexure H. And there is also a circular at Annexure L, my lords. I think page 43.
So the suit is decreed, not an interim order.
Suit is decreed.
Decreed ಅಂತ ಹೇಳಿ.
Yes.
Interim order ಅಂದ್ರೆ ಅದು ಬೇರೆ.
Right. Suit is decreed.
Where is the circular? And against whom have you complained? ವಿಷಯ ಶ್ರೀಮತಿ ಜಯಮ್ಮ ಮತ್ತು ಶ್ರೀ ಮತ್ತು ಇತರರು. They are not parties to this suit.
This Shanmugam is party to the suit. He is the defendant number 2 in the suit.
Who is Jayamma now?
Jayamma is his sister. Shanmugam's sister.
Shanmugam is a party.
Yes.
They have not sought for police protection, my lord.
I lodged the complaint.
For the execution
They
and
drove
moreover,
me
my
to
lord.
again they are driving me to the civil court. Kindly see Annexure H in page 66. They say that idu civil swarupada
It's already been decided.
How many? Pardon
It's
me?
already been decided.
Yes.
Kindly see the decree, my lord.
Restrained
Only
from.
says that
Yes.
defendants or any other persons are restrained by permanent injunction not to interfere with social property. They have not sought for any police protection in execution protection.
May not see that is the interim orders. Yes.
Yes,
This is a final decree.
that apart, my lord, if
You can
if my
file
lords may
execution
kindly see the
proceedings. You can file execution proceedings where you can get this order.
Yes, but the problem there, this Shanmugam, it appears that he is a permanent customer to the police station. He is of that type person.
Allah, get a file execution to execute this order. Your relief is in executing this order, judgment.
I am requesting for police help to implement the order.
You are making this court into execution court.
And
You have a decree in your favor.
yes,
You want the police to execute the order. Your remedy is in filing execution proceedings. You are not filed execution.
I have not filed execution. And there is a circular issued by the
2021
second respondent,
order.
my lords. Whenever a party produces an order of the court, least required of the police is to give protection.
Yes.
And following that circular, this honorable court has already passed an order, my lords. See,
If there is an order of the court to give police, you have a decree, Mr. Muralidhar, you have to execute it. You can't short circuit.
but by then these people will occupy the property. The state is duty bound to protect the.
Decree of the year 21, which you want to enforce now by this. Till now, you had no problem.
No, I had the problem, but whenever I go to the police station, they drive me to the civil court.
That is why.
Even now, they are
But,
asking me to go to the civil court. How many
He
times I
accepts
should
notice
seek?
for respondent 1 and 2. Petitioner is before this court seeking for the following leaves. The petitioner had filed a suit in OS number 13 Additional City Civil and Session Judge Bangalore against one Mr. N. Raghu and Mr. S. A. Shanmugam, which came to be decreed on 14 December 2021, restraining the defendants therein from interfering with the possession of the petitioner. Thereafter, the petitioner had submitted a complaint on 5/8/26 against Mr. Shanmugam with the respondent police, contending that he is committing criminal trespass into the property and stealing mud and soil and destruction of property and threatening him and his family. The injunction, there being a decree of injunction restraining Shanmugam and Raghu from interfering with the possession of the petitioner, it is for the petitioner to file necessary execution proceedings and seek for appropriate reliefs therein. The decree having been passed in the year 2021, the petitioner has not sought for any execution of those proceedings, that decree till now. but has directly approached the jurisdictional police for grant of police help and protection. However, even the complaint indicates that there is already a criminal trespass. ಅದು ಹೇಳಿದ್ರೆ ನಿಮಗೆ ಕಷ್ಟ ಆಗತ್ತೆ ಇದು.
One more suit is also pending against.
In that view of the matter, reserving liberty to the petitioner to approach the execution court seeking for appropriate relief, the petition stands disposed. Why you have not gone to the execution court is that it's already been taken possession of.
No, possession, I am in possession.
Read your complaint, Mr. Muralidhar. Complaint al nodi.
He has not taken possession from me.
Nodi complaint al.
Complaint, ಅವ್ರು ಬಂದ್ರು ಅಷ್ಟೇನೆ JCB ತಗೊಂಡು ಬಂದ್ರು ಅಷ್ಟೇನೆ.
Nodi.
I am in possession of the property.
Prayer is also wrong, my lord, because I've sought for mandamus. Already endorsement is issued.
Next.
B group matter, serial number 34, Manu Prabhakar Kulkarni.
Retailers Association of India.
Challenge to some provisions of the statute, my lords.
There is Retailers Association of India also.
Name boards.
How many are members of this Retailers Association of India?
There are, I have implemented some members.
The way that you are claiming is you are representing the whole of India, so
Only some members are here, not all.
declare that so and so. Yes, readings are complete. But now it is GBA.
Please.
24 matter. State of Karnataka, BBMP, Union of India. And you challenge the virus of
Of a state legislation, my lords.
order sheet code. Notice has been issued to the AG.
It was Union of India, my lords, it just says served. The learned advocate general had appeared, my lords.
Yes, but notice has not been ordered.
Please.
The virus of the Kannada Language Comprehensive Development Act 2024 having been challenged, issue notice to learned advocate general. Learned AG accepts notice on his behalf. Learned counsel for respond number 2 and 3 submit that the BBMP is now merged with the Greater Bangalore Authority. In that view of the matter, the Greater Bangalore Authority is brought on record as respond number 5. Represented by its committee is brought on record as respond number 5. All 5 will.
Please. I'll carry out.
The Greater Bangalore Authority and the 5 corporations are constituent corporations are brought on record as respond number 5 to 10. Counsel for the petitioner to carry out necessary amendment and file amended cost title. You will take notice for all of them. Shri BL Sanjeev accepts notice for respond number 5 to 10. And AG and Shri BS Srinivas seek for and are granted. When will you file? Two weeks time to file their respective statement of objection. Objections, if any, by 10th September, failing which will be taken as not filed, matter proceeded with. Relist on 17th September, interim order earlier granted is extended till next date of hearing.
But will your lordship also permit me to serve the ASG for respond number 4?
I will. And ASG accepts notice for respond number 4. Is directed to accept notice. Is not here.
Great.
35, Krishna BS.
Despite the order dated 29/6/26, none appears for the petitioner today also. Appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Last date they were asked to place on record. Last date of occasion they were asked to place on
ಸ್ವಲ್ಪ
record.
ಜೋರ ಇನ್ನ ಲಂಚ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ ಗೊತ್ತು, ಬಟ್ ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ.
On last date of occasion, the respondent
My lord,
was
this matter
asked to
was
place on record.
posed.
ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Sports persons to be eligible under various schemes. Yes.
My lord, I'm placing this report. My lord, as far as the petitioner is concerned, my lord, his
ತಗೊಳ್ಳಿ.
grievance.
ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇರ್ತೀನಿ, ನೀವು ಅಲ್ಲಿ ನೋಡ್ತಾ ಇರ್ಬೇಕು. ಎವ್ರಿ ಟೈಮ್ ನಾನೇ ಹೇಳೋದಿಲ್ಲ.
My lord, as far as the grievance of the petitioner, that was resolved. But this is a case, my lord, where he is the sports person involved in rifle shooting, my lord. His case is before the court that he was not selected for the 10 lakh rupees benefit for. Now, my lord, he is considered as a better bet for 2028 Olympics, and that amount has been paid. He has been selected this year.
If you had given him earlier, you would have been even a better bet.
So he was under 14, my lord. There was another sportsman who was under 21, and he was given. Now, my lord,
To increase the spread, Mr. You can't be reducing it.
That's a policy decision, my lord. Finance involved.
That is why India doesn't get medals. Because the
I'm-
first elimination is happening within India,
I'm
within each state.
I'm wholly with the court on this issue, my lord.
Mate?
But then, my lord, however, my lord, now that we just placed this record, on record, the lordship asked what are the benefits, my lord, that are available and how they are identified. My lord, the recommendation comes from their own federations, my lord.
That is the problem. Federation doesn't do it, then everybody washes off their hands. Federation did not do, we did not
No, my
do.
lord, the federations recommend the names amongst them, depending upon the performance in various levels. However, my lord, now this petitioner, we have given him the 10 lakh rupees amount for the thing.
That is under different scheme, my lord. That is under Target Olympics 2028. Now he has been selected for the World Cup. He has been selected for the World Cup for because of international. As on 2023, he has won the 64th Asian Championship, my lord. As on the date of the scheme, I was entitled for the scheme benefit of the scheme. In spite of due difficulties, financial difficulties, he had achieved so much. That is under Target Olympic scheme, my lord. That is not under the which scheme I was entitled for. That is Amruta Datta Krida Yojana was the scheme that was introduced in 2023, for which I was entitled. But now as I got 10 lakhs from Target Olympics 2028 for that. If I take, if I am the beneficiary under Target Olympics 2028 scheme, I can't apply for the next 2 years. I can't apply for any of the schemes, my lord. That is the embargo which is there. No, since I am not entered, I was not paid for 2023. Till now, I have paid. Now they have paid. And if I am paid now, till 228 to 28, I will not be paid.
My lord, one thing, my lord, fairly, my lord, we have to balance the number of sports. It's not the only one stream, my lord. My lord, two people were identified. One was him and the other person. He was 21, under 21. He was selected. Now 10 lakh rupees has been given to him. Now, my lord, just because he cannot apply for any other scheme for 2 years, my lord, there are other sportspersons also in this country, my lord. With
But a
limited
person
budgetary
who
allocation.
is done, you should give him also. You
I
should
would
give
like
others
to bring
also.
to your kind notice that
But now that we have given, my lord, now he comes and says that that embargo.
All of you have to understand one thing is that the shelf life of an athlete is very limited.
Yes, ma'am. Very much. That is the
In
reason why,
that
my lord,
age group only it works. After that is veteran, retired.
that's the very case with the previous thing, my lord, the last year. He was under 21. If he had not been supported,
that
at
is
that
that
point,
is not the case,
he was
my
under
lord.
14. He's under 14.
He has been selected even though he has not won any medal, my lord.
10 lakh
He
rupees has been given to
he
him.
has not won any medals, either national, not
Ready
state,
and
nor
address
international.
arguments. We won't accept this one. So address your arguments. We'll see what is to be done. If he succeeds, he succeeds. Otherwise, if there's something,
No,
some
his
mistake
prayer
done by
is,
you.
my lord, that he was not considered for that amount, and now we have sponsored him, and 10 lakh rupees is already paid.
Under what scheme? Under same scheme? For the same year?
It is a Target Olympic
Under
scheme.
different budgetary allocations and the sports authority. I will argue the matter.
We'll give you an order in some other matter. WP number 20391 allowed, in which you are not a party, we'll dismiss that.
Difficulty is this, my lord. We are a large
That
country.
cannot be.
No, we are a large country and we have to limited budgetary allocations, my lord, and
We are a large country with large resources.
large
There's no-
resources and of course, a large talent pool also, my lord. But then, my lord,
with more or less the least number of medals. The prestige of the and you will spend so much money on so many things and not on this, which has a prestige across the world. You have to prioritize. They also have to be given, and their shelf life is very short.
I agree.
So when will you get ready?
Anytime after 2 weeks, my lord.
Not 2 weeks.
1 week.
That AGA has filed a memo along with certain details. The same is taken on record. Relist on 19th at 2:30 p.m. ಏನು? At the request of counsel for the petitioner, relist on Monday, 17th.
Your Lordship, serial number 64, Your
Interim order
Lordship.
earlier granted is extended till next year.
Serial number 64, Your Lordship.
64. Yes.
I seek time, Your Lordships.
At the request of counsel for the petitioner, relist on 29th September. Interim order earlier granted is extended.
Much up.
Serial number 83, Your Lordship.
83.
May be taken at staff list, Your Lordship. Defreezing method. Serial number 67.
Externment order, externment order, AC ಮಾಡೋದು 67.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಡೇಟ್ ಕೊಟ್ಟು ಮುಗಿಸ್ಕೊಡ್ಬೇಕು. ಅವನಲ್ಲಿ ಎಲ್ಬರ್ಗೆ ತಗೊಂಡ ಆಗ್ತದೆ.
ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಮುಗಿಸ್ಬೇಕು ಅಂದ್ರೆ
ಆ ಡೇಟ್ ಕೊಟ್ಟು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕಿ ದಯವಿಟ್ಟು.
ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳ್ಬೇಡಿ, ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಇವನ್ ಹರ್ಡ್ ಯು.
ನೋಟಿಸ್ ಆಗಿದೆ ಅಷ್ಟೇ. ನೋಟಿಸ್ ಅಲ್ಲಿ ನೋಟಿಸ್.
ಇವಾಗ ಡೇಟ್ ಬೇಕಾ ನಿಮ್ಗೆ?
ಡೇಟ್ ಅಂತಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ. ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕಿ. I am grateful at that.
67 at the request of counsel for the petitioner, relist on 17th September.
17th
September.
All the best, madam. Enjoy the wedding.
Court officer. Court officer.
Oh no. 78 I think. ಮೂರಾಯ್ತು, ಮೂರಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಇದೆ ನೋಡಿ. 12/6/23.
Sir, serial number.
ಮೂರೇ ಅಟೆಂಡ್ ಆಗಿದೆ. 64, 67, 30 ಅಲ್ಲ 40.
Court officer, the serial number 51 mention ಆಗಿದೆಯಾ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್?
51
ಹೌದು, ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ
ಇದೆ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
41 ಇದೆ.
41 ಅಲ್ಲ 51.
ಇದೆ ಮೇಡಮ್, 51 ಇದೆ.
ರೈಟ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಇದೆ. ಇದೆ. ನೆಕ್ಸ್ಟ್ 230 ಡಿ ಬಿ ಇದೆ ಒಂದು, ಆಮೇಲೆ 230 ಲಿಸ್ಟ್ ತಗೋತಾರೆ. ಅದೆಲ್ಲ ಮುಗಿದ್ಮೇಲೆ 230 ಲಿಸ್ಟ್ ತಗೊಂಡಿಲ್ಲ ಸರ್ ಇದೆ. ಇಲ್ಲ ನಾನು ಕೊಡಲ್ಲ, ಈಗ ಮುಗಿದ್ಮೇಲೆ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಆಮೇಲೆ. ಇಟ್ಸ್ ಕವರ್ಡ್.
Court officer. Free.